Good morning. Gabrielle closed the door, so I think that's my cue to welcome you all. I am Jessica Haught. I'm one of the associate deans here at the College of Law, and on behalf of the dean and my colleagues, I'm pleased to welcome you to day 2 of the West Virginia Law Review Symposium. As you can see, Morgantown in February does not disappoint. So we are particularly grateful for everyone who has traveled with us to be with us both yesterday and today. As many of you know, the West Virginia Law Review is the 4th oldest law review in the country. Its mission is to advance legal dialogue through a student-governed process that cultivates leaders, fosters collaboration, and provides a platform for diverse scholarship. This year's topic on home rule certainly fulfills that mission. This timely and important topic is rich with a variety of diverse and exciting topics for scholarship, from LGBTQ protections to gun regulation to the impact of the West Virginia Home Rule Pilot Program, criminal justice reform, consumer law, issues in environmental and energy law, and the role of courts. I'm sure you would agree that that is a diverse area of scholarship. I would like to thank all of the panelists, including the scholars, experts, and attorneys that have volunteered their time and traveled to enrich this discussion. I also want to thank the panelists and speakers for their time, including my colleagues who have either volunteered to serve as moderators or to also serve as panelists. I'm very fortunate to work with such amazing law professors and scholars who dedicate their time to supporting the work of the Law Review in the College of Law. And I would be particularly remiss if I did not take a moment to thank all of the members of the West Virginia Law Review who have worked tirelessly to make this symposium a success. We have amazing students here. I hope you've had a chance to speak with our students. So I'm just going to have our Law Review members sort of raise their hands. And I would like all of us to give them a round of applause for their very hard work. Specifically, I do want to recognize that this symposium would not have come together without the individual efforts of our symposium editors, Gabrielle Markham and Austin Rogers. Could you please raise your hand? Thanks to Gabrielle and Austin. They have done a great job. I don't see Professor Richardson in here, but for those of you who know, Professor Jesse Richardson was our faculty symposium advisor, and his expertise also made this symposium a great success. So we are incredibly grateful for Professor Richardson's time to advance the scholarship here today. Professor Joshua Weishart, I don't think he's in attendance, but I do want to thank him as well. He is our faculty advisor and director of our Writing Center. Melanie Steinling have worked also this year with our West Virginia Law Review. We have a number of faculty and staff who work behind the scenes to make this event a success, and so I would like to thank all of them. We are, again, just grateful that you have made the time and effort to travel here to be with us today. So I look forward to another day of great discussion and dialogue on this important topic of home rule, and we are just pleased to have you. So enjoy day 2. Thank you very much.
Good morning, everyone. My name is Haught, DeLap, and I'm the Justice Franklin D. Cleckley Fellow for the West Virginia Innocence Project. The Innocence Project is part of the clinical law program here at the College of Law. Today, I am joined by 2 wonderful panelists from Marshall University. Professor Casey Baker, all the way at the end there, serves as Assistant Professor of Legal Environment in the Division of Accountancy and Legal Environment at the Lewis College of Business at Marshall University. He teaches topics such as legal environment of business law, of business and business law, government regulation, healthcare law, and entrepreneurial law. His research covers a variety of commercial and corporate law topics, including debt collection and bankruptcy, corporate governance, securities, and energy and natural resources. In addition, Professor Baker maintains a practice of law in West Virginia and Ohio, focusing on governance and transactional matters for small businesses and not-for-profit organizations. Professor Ralph McKinney, Jr., to my right, is an assistant professor of management at the Lewis College of Business at Marshall University as well. Professor McKinney has authored a number of publications concerning cryptocurrency, economics, forensic business practices, human resource management, indigent criminal defense, and poverty. He holds degrees from Aston Business School at Aston University in Birmingham, England, Marshall University, and West Virginia State University. Additionally, he is a licensed private investigator. Today's panel focuses on home rule and criminal justice reform. Home rule allows municipalities to respond to individual demands through tailored regulation, but greater local control can cause tension between the state and local governments. Our discussion today will center on one issue in particular, the indigent defense system in West Virginia. I'll start by asking Professors Baker and McKinney some questions about the indigent defense system and how it works on a state and local level before opening it up for questions at the end. To start, with both of you having diverse research interests and different backgrounds, what brought the 2 of you together to co-author an article on indigent defense in West Virginia?
So, our background, as you heard, is in business. So why do we have 2 business professors up here talking about criminal law? Well, because we come at this from a policy perspective. We come at this from an administrative perspective, trying to sort out what is the mission, what is the purpose of an indigent defense system. Being both of us native Appalachians, how many native West Virginians do we have? Okay, so good. We have a good crowd here. There was a book I ran into a couple years ago by a guy named Colin Woodard, I think, discussing the 11 separate nations within the United States. And West Virginia is part of a collective called Greater Appalachia. One of the hallmarks of Greater Appalachia is a distrust of government. And this is sort of ingrained in us from a cultural standpoint. And as I talk to my undergrad business students, we spend a lot of time discussing rights and duties as citizens, as business participants. And I can talk to them about rights, and they're familiar with our rights. They can recite to you, all the rights that are protected by the Bill of Rights. But when you ask them to apply that in a context, I give them an assignment. There's a great video out there by a guy named James Duane. He's a professor at Regents University School of Law in Virginia. And in this video, Professor Duane discusses why you should never talk to the police. Under any circumstances, never talk to the police. And I show this video to my students, and their minds are blown. And there's a disconnect there. You guys, we talk about our rights. We talk about the rights we have. We talk about the things government can't do to you. And then you're totally confused about the role of law enforcement in our society. Not to say that I have any specific issue with law enforcement. Very nice people in law enforcement. But they have a role, and the role is not necessarily to protect the individual accused. That's where the attorneys need to step in and advocate for those criminals. That's our role in this system. So I think coming at it from that perspective, helping our students understand that rights mean something, and unless you are willing to stand up for your rights, and there's someone there willing to stand up for your rights in court in an adversarial proceeding, what good are those rights?
And just to add to that, with the West Virginia Public Defender Service, I actually served as the Director of Operations and Director of Accounting and Auditing, and I was there for about 14 years. In that time, I was able to meet and work with some various wonderful people, understand that DNA evidence actually first started in Kanawha County by Lonnie Simmons and George Castell in the public defender system, and understanding, looking at these issues and saying, we've got a lot of resources, but we've got to make sure that we effectively use those resources, because the money that we're spending on erroneous stuff, or maybe that's not as effective, we need to actually find the better procedures. And then we actually started trying to move towards a more holistic approach for individuals that are accused of crimes.
Wonderful. So Professor Baker, brought up the rights of citizens. Professor McKinney, could you tell us a little bit about the right to counsel for criminal defendants who are unable to afford an attorney, and what is the source of that right?
Okay. I think it really starts before the United States. You have John Adams, who was the first vice president and the second president of the United States, that actually did counsel some of the British before the country was founded, and I think that led to the Sixth Amendment, the right to counsel. Now, what's interesting about that is in 1911, we actually had public defender offices that were operated from donations in New York and California were the two prominent offices, one on either coast. So you had a lot of people that were doing this work free of charge, that were assisting their community and were looking at a holistic approach. So, 1911 is quite different than the 1963 Gideon. And I think with that, it really solidified that the fact that there's a triggering event when you're going to remove somebody's rights and potentially face incarceration and remove their right of as an individual to engage in fruitful employment, earn a living, then you have to have some kind of method of due process and afford legal counsel. Now, the problem with that is they never exactly said how much legal counsel that was, how much money is that going to be? And the other issue is what quality of legal counsel. So those are some of the issues that when I was at the Public Defender Office, we wrestled with to understand, there's a limitation with a legislative appropriation. So we were always going back and saying, well, can we get a supplemental appropriation? Well, guys, how much you need? Well, maybe $12 million. That's a lot of road money for some people. And unfortunately, a lot of people that are incarcerated don't vote for our politicians. So who has, who's able to advocate on their behalf? And that's partly why I'm really interested in making the system much more robust, and potentially looking at how we can do this through home rule and how that can be incorporated.
Speaking of home rule, Professor Baker, how does the state's compliance with the right to counsel under Gideon involve multiple levels of government?
Well, it all comes back to money. What's your funding source? Right now in West Virginia, it's public. It's state money. The state controls the purse strings. But those actual spending decisions are very frequently made at the local level. When you talk about the actual billings that attorneys are doing and submitting for approval, a lot of that used to occur through, and Ralph has some firsthand experience in some of these issues that pop up, but the judge has to sign off on those, which creates a court order. So now you possibly have conflicts between legislative and judicial branches. The legislature authorizes the spending, but now the court's ordering the spending. You also have, you throw in an extra element in West Virginia where you have these private corporations that are actually quasi-governmental entities, the public defender corporations. And it's kind of tricky coordinating those with the IRS as 501c3 organizations, even though their bylaws are established by state statute. So you've got federal, state, local elements all involved in this. Ultimately, though, it's going to come back to the money. What's the funding source? If you have, as Ralph mentioned, in the early 1900s, the private funding, if you had more private funding of these sources, obviously you can eliminate some of that concern. But again, the responsibility is on the state to fund these sources and assure the rights of our individual citizens to a fair trial, to due process. And that's what it comes back to. That's the charge of all of our government officials, is preserve due process.
I'll ask both of you this. If the responsibility is on the state, then in your opinion, is the representation of indigent criminal defendants a local matter? And if so, what effect does home rule have on the system?
Yes, I think it is a local matter because when you think of a public defender corporation or appointed counsel, those are county decisions. Those are local decisions. Charleston is different than Morgantown, is different than Martinsburg. And so the economies are different. The rules and regulations are different. The support services outside of just the legal counsel, such as public assistance, SNAP programs, may be different. Services for medical care, for substance abuse are different in different areas. And I think those decisions really have to focus locally because those are the individuals that can identify the resources and look at this from a holistic approach. The way the system is currently, we do have some social workers in the program that allow and do reviews. Sometimes we do psych evaluations, but there's not a real central office that looks at a person and says, okay, you need indigent representation, but we also have to maybe cure some of the issues with food insecurity, with medical care, access with people with disabilities, because those are also individuals that may need legal representation. So yes, I do believe it's a very much a local matter.
Professor Baker, what about you?
And I'd echo that. I think think globally, act locally is well, a phrase that we talk about in our business programs. Everything has a local component to it, and that's really the tension that we see in the system as it is you have these local problems, local prosecutors, local courts, local defense attorneys that are hamstrung by the state funding apparatus. If you could democratize that, get it down more to the local level, you may be able to see more custom designed programs, again, more holistic approach at the local level as opposed to the one, the cookie cutter model that's going to come from those higher levels of government.
Before we turn to the specifics of the system here in West Virginia, Professor Baker, are there guiding principles for systems that are designed to provide legal representation for indigent criminal defendants?
Oh, sure. In 2002, I think it was, the American Bar Association came out with a set of 10 guiding principles. And you could probably really consolidate those into about 2 or 3, maybe 4 guiding principles if you really wanted to. And it's not much different than any representation circumstance. You want competency. You want access, equal access to counsel. You want a sense of fairness in the process itself. You want expertise. You know, certain criminal cases are more complex than other criminal cases, just like certain civil cases are more complex than other civil cases. You need to develop some method within this system that you can assure that those complex cases are treated not on the mass production model of running however many cases we need to through a court in a single day. You look at some of these dockets and there's 300-400 cases set for a single day. If we've got an indigent defense or an indigent defendant who's facing a murder charge, we probably need to spend a little bit more time and energy on that than one of the various minor misdemeanor drug possession type cases. So developing a system where you have attorneys who have the requisite amount of expertise, requisite amount of time, of resources available to them to provide an effective defense is really at the core of those guiding principles.
With those principles in mind, let's turn to West Virginia now. Professor McKinney, what does the indigent defense system look like in West Virginia?
It's actually a mixed system. So you have, in some cases, you've got these judicial circuits, and as Casey mentioned, that in each judicial circuit there is a public defender corporation. Now the term activate is important because currently there are 18 corporations that have been activated that cover 19 judicial circuits. And in some of those counties there is not a public defender corporation, but there's appointed counsel, and those are private panel attorneys that are basically contractors. So the decision to open a public defender office is a financial decision. It is a local decision because it requires the county commission, the county bar to come together. Appointments are made to a board of directors. The articles of incorporation are by statute, and that's part of the process. And even if you have a public defender corporation, you still have private panel attorneys, the appointed counsel, to actually also assist with the work. Because the issue is when you arrest a group of people, you've got 5 people. The public defender office should only represent one of those individuals because you've got conflict of interest. Or you may have a public defender office that may not have the specific expertise associated with the case, and it needs a complement from a private panel attorney. So that's kind of the way the system works. There's a centralized organization, West Virginia Public Defender Services, that oversees and grants organizations funding for the public defender offices, but they also act as a payment agency, a payment conduit for the appointed counsel. There is an indigent defense commission associated with that advises the public defender services. So there's questions that we could always ask: how can we make it more effective? How can we use our local governments to actually create a better working relationship with the state agency to where we can actually tackle the issues locally, like the opioid epidemic, other type of economic issues, and holistic approaches like food insecurity. That maybe sometimes people commit crimes because that's their choice, or when they look at it, that may be their only option.
Professor Baker, could you talk a little bit more about how the system is funded?
It is largely, there's a state appropriations. You've got, there's a line item in the budget that is passed to PDS, and then PDS oversees the billings, the funding mechanism of the separate panel attorneys and the public defender corporations, right?
Yes.
And then the distinction between those two organizations.
Basically, yes, there is an appropriation from the legislature, public defender services, each public defender corporation submits an annual application for funding. Public Defender Services reviews that applications, make the determination, and justifies those budgetary or grants, and then they issue grants to those offices. Those are actually, the legislature at one point in time had those in one single line item, so both the appointed counsel and Public Defender Service were operating out of the same budget. And then there were some issues associated. Well, public defender corporations are getting better treatment. You're always shorting us money because the money would run out and you'd have to request a supplemental appropriation. And during that 6 months that I'm waiting for payment, or a year, I can't operate. So they actually split those two out. The legislature was smart enough to do that. And so you have a separate line for public defender offices and a separate line for appointed counsel. And at the end of the year, you can transfer money from the public defender corporations to the appointed counsel to reduce the supplemental appropriation that's requested. Part of the strategy that the West Virginia Budget Office had, because it's always, why does West Virginia Public Defender Services actually always ask for a supplemental appropriation? That's actually a political thing from the state. That's a political agenda from the state, because the idea is, if we gave them all this money, they're just going to spend it on legal representation. So we're going to make sure that we allow this much, and at the end of the year, we're going to find the agencies that maybe underspent and did this and transfer the money. I remember there was a lot of legislative changes in 2010 where they changed the billing practices from 4 years after the last date of service to 90 days. And we estimated that we needed about $20 million to take care of the backlog. $20 million is a large amount of money. So it was Cart Goodwin, and the governor was Joe Manchin, and Jack Rogers sat down and they had a discussion. And they said, well, there's an easy fix. We're just ask for the money. And it's like, how are you going to ask for $20.5 million? And they said, well, simple. They put it and attached the bill to a teacher pay raise bill and said, okay, teachers, okay, have a union. They said, okay, so if you vote against the teacher pay raise, you vote against the appropriation, and it read something like, there's going to be a $1,500 authorization from the state of West Virginia for teachers, provided that the county fund it. Well, the county didn't have to fund it, so there's no funding strings associated with that. But it was a political move to transfer the money from the West Virginia Lottery Commission to the Public Defender Services. So when you're talking about funding issues, that's at the state level, and I think that sometimes the local level can help influence that and really understand the needs. Because at the state level, it was, let's make a guess, and that's part of the problem.
And just kind of, you talk about, okay, alternative funding models. Ralph was telling me something he found in the way they fund indigent defense in Germany. You want to talk a little bit about that? This is interesting.
Now, in Germany, everybody's entitled to indigent representation. So if I'm over in Germany and I get arrested, I can get that free of charge. There's no problem. Now, how do we fund this? Insurance premiums. So in Germany, everybody that's a homeowner has insurance. Everybody that's a renter has homeowner, and it's part of the policy and coverage for the insurance. So there's a portion that's taxed that goes into a central fund to fund those individuals that don't have the insurance. But if I'm a homeowner and have insurance, I just put a claim against my insurance and they pay for it. That's an interesting approach.
That is different than the system we have here. So before we're talking about the German system, you talked about local needs. So do we see specific local needs here, county by county, for the public defender corporations? Or what local needs would counties be responding to that the state funding decisions might not?
I think in some cases, if you're looking at the opioid crisis, those may impact more so. If there's an economic slump in one area, that could be, it's basically the same issues. The person is accused of a crime. And I think the solutions, when you're looking at a holistic approach, may be different county by county. For example, Weirton had a lot of steel industries. Those steel industries are not there. So what are the jobs? What are the jobs available to an ex-offender? And I think that's where you could have the support that's necessary from the local counties to show I want to say empowerment zones, but where can these people find sustainable jobs that they can be members of society after the fact? Or is there going to be a stereotype of having potentially a criminal conviction or an investigation that stops me from getting work?
And just to kind of maybe take that a little bit different, and I don't know that I want to use the term NIMBYism, but a lot of these local issues, opioids, job loss, you can say what comes first, the chicken or the egg? Does crime result in these issues, or do these issues create crime? But the fact of the matter is, it's a much easier political sell to say we're going to get tough on crime than it is to say we're going to take a holistic approach and try to solve these other problems, and then maybe that will resolve the crime problems that we're facing in our local communities. I do think that mindset is changing a little bit, and the opioid crisis, I think, has prompted a lot of that. Just the widespread nature of that issue, especially here in West Virginia, but I don't think we're there yet. I don't think we're there yet to the point where we look at this and say, this is politically a popular option. I've got a client I was just talking to the other day. It was a recovery center, and they were getting some grief from one of the local communities about homelessness, and the recovery center is being blamed for the local homeless problem. And it's, no, we're there to treat the homeless problem. We're not dumping these folks on the street. We have our doors open. These people are homeless not because of us. They're homeless because of the substance use issues. And we're trying to give them shelter so that way they can get into recovery. So you have that. You do still have that element out there that, again, like Ralph said, you take a holistic approach and you see that this criminal representation is just one part of a larger social problem that we've got to change our mindset on in addressing these problems.
Both of you have used the term holistic defense. What is holistic defense? What does the model look like in West Virginia? Is there one model, or do we see different models for the different public defender corporations?
Again, and I think it's back to that point of crime is one part of a social issue, or of a bigger social problem, which is lack of opportunities for folks. Idle hands do the devil's work, right? That's the old saying. Lack of opportunities, jobs, economic, entrepreneurship. You combine that with reliance on public assistance. Indigent defense shouldn't be any different than any other form of public assistance. We have an entire medical industry that's based on a model of reimbursement from public funds. Why is our legal industry not also thought of in the same light? Why is it that public defenders make less than anybody else in the legal industry? Why have we shifted that incentive system such that attorneys are economically discouraged from engaging in indigent defense? So I think when we say holistic approach, it's re-envisioning criminal defense as just one aspect of this social safety net.
And to add on to that, currently with the public defender systems, they may have a social worker in office, but those individuals are looking at the cases and the legal aspects associated with abuse and neglect. They're not there for counseling. They're not there to help with the housing problems or the other issues. We have Legal Aid of West Virginia, which does assist with some of those issues. If there was an opportunity to create a shared office, you would actually be able to use the same accounting systems, maybe some of the same receptionists and staff, but you're treating the individual as an individual and saying, what we're going to do is look at your food insecurity. We have, again, with the healthcare system, we have economic service workers or people from the Bureau of Children and Families that take applications for public assistance stationed at hospitals so that we can get the appropriate Medicaid payer information. Why can't we have those individuals also at some of the public defender offices or at a municipal office if there's no public defender, maybe at the courthouse to take some of the applications to where it would be accessible. And that may actually help with some of the individuals. We're not there yet. So.
Now, Professor Baker, you mentioned the salary of public defenders, and I thought one of the most interesting parts of your article talks about public defenders and whether they're more cost-effective than appointed counsel. So let's talk more about the mixed system, how that works on a funding level and salary level, and if you do think that public defenders are more cost-effective than the appointed counsel system.
So I guess what is cost effectiveness in this context? I think that's number one, a question. What's your mission? What's your goal with any kind of indigent defense system, be it an appointed counsel system or a public defender corporation? But set that issue to the side. I think generally what you see is your public defender corporation attorneys are salaried. So they are getting a flat salary regardless of the volume of cases that they handle, which means they're usually handling a large volume of cases. These are typically the folks in your municipal courts running through the 200-300 cases in a day. So now you have to worry about workload. You have to worry about competency. Are these attorneys getting sufficient time with their clients to provide them an adequate representation? The flip side of that are your appointed counsel systems, where until just recently we were making what, $45 an hour for out of court and $60 for in court. You would be hard pressed to find a private attorney who will take $60 an hour for any work.
Now it's 60 and 80.
Now
which
it's
is,
60 and 80,
yeah, which
a little
is,
bit better.
Yeah.
But still, find an attorney who will do a will for somebody for $80. Standard, simple will. I've tried that model. $80 don't cut it, I promise you. So again, I think it gets into managing resources in light of the goals of whatever that particular criminal docket, that particular criminal case situation may entail.
And to add on to that, if you look at what's the metric, are we going to go by cases closed? Well, then why not plea everything? That's a case closed. Are we going to look at taking everything to court? Are we going to look at the number of charges that are filed and then dismissed as a metric? So there's a number of ways that we can look at this, but until we actually fully understand and create a mission, other than the mission is to defend the indigent, that's kind of a broad spectrum. How are we going to accomplish that? What are our objectives? What are our minimum standards? And again, with the appointed counsel system, you know, the salary for 45 and 65 was a 1990 case, and basically until recently, for over 25 years, it's the same rates, you know, with no inflation. With the public defender offices, those individuals get a salary periodically every week or every 2 weeks. And with the appointed counsel, I have to wait till the case is closed and I can't bill periodically. So I'm going to have to front some of the money. So some of the, I may not get an expert. And if I do, I have to go through a voucher system to do a third-party payer, essentially, to do that. So that's going to be another issue when you're looking at quality as well. So sometimes there's some tension between a public defender corporation and an appointed counsel because of the benefit issue, because of the compensation issue, because the way they're a competing environment. So they're good to work together, but I think with the payment for appointed counsel, that needs to be a little faster.
So to follow up on that great discussion of how you measure cost effectiveness when it comes to delivering legal representation, what was the metric that you were looking at and what was your finding for comparison?
I like the breakdown that we had it was a purchase price parity. Help me out here. What was the?
It was a
metric?
purchasing price of parity.
Yes,
And
on a GDP per capita basis,
Mhm.
right?
so the
Yes.
idea is this: bread in Morgantown
Yeah.
is going to be this different price than bread in California than the bread in South Africa. And from those concepts, if we look at the gross domestic product or the state, then we consider that sort of like the consumer price index, and we kind of match that to figure out where we are in indigent representation. What are we spending as a state as allocated resources versus other states?
And not just other states, but other countries.
Other
you
countries.
You can use this metric across cultures worldwide.
Yeah, because it eliminates the need for exchanging monetary issues or currency calculations or anything like that. And what's interesting is Venezuela, South Africa, actually spend more than in their indigent representation than El Paso, Texas. So that's kind of a, wow, where are the resources? Because if you're going to be successful in any job, in any management, in any type of business, you have to have resources. And limiting those resources or not funding or giving support from a political standpoint, from a policy standpoint, will make you fail every time.
And so where does West Virginia fall on that spectrum? Actually, not too bad. Near the top of the list in the United States is on that metric, which shows you just how bad this problem may be nationwide. When you're talking $60 per hour ranks well within the United States. That's a scary thought, especially when you've got this. You talk about mission. As a nation, our mission is right there in the preamble, right? We, the people of the United States, in order to form a more perfect union. Establish justice is the first thing we talk about.
You mentioned how West Virginia is funded compared to other systems throughout the country. Throughout the country and the world, and how it measures up. So let's talk about how the mixed system in West Virginia compares to other state systems and the federal system. Professor Baker, do you want to talk about that, or Professor McKinney?
Okay, yeah.
You're the economist.
I'm the economist. Okay. So West Virginia, when we looked at it, was about the second one. The United Kingdom spent a little more in funding than West Virginia. But considering that we're on that, that's pretty awesome. Now, what's kind of interesting is the public defender system in West Virginia has actually been studied by Spanchenberg, by several other individuals, and some of the UK systems that they do for indigent defense was modeled after the state of West Virginia, which is kind of, wow, that's kind of interesting. So I did have a chance to go to the Birmingham office in England for the and they call it Public Defender Services, and they ran it very similar to what we do here. And what was interesting is Leon, the individual that was running the Public Defender Services, was a graduate of Ohio School of Law. So, again, somewhere local. Japan models their system from the United States. And so it's kind of amazing to see that West Virginia is actually one of the front runners for these type of programs. But are we doing enough? Maybe not. Maybe it's time to reinvent and reinvigorate and make the system a little more robust, because we can't be satisfied with just being, we're at this level. Let's take it up another notch.
Before we turn to reforms and recommendations that you would make based on the system that sounds like a model for the country and the world, what issues do you find with the current West Virginia system? Have there been any problems that you've identified ethically or otherwise with the current system?
And again, Ralph ran effectively the operations of Public Defender Services, and he's got some great war stories in this model that they had to sort through in the payment reimbursement. He's telling me these things, and I'm like, that's an ethical violation. That's an ethical violation. That's an ethical violation. What?
My favorite question. My favorite question. Yeah. How many hours are in a day? Just asking. So we had one individual that billed 56 hours in a day while they were on a Caribbean cruise. Yeah. And there was one individual that over a 2-year period, 176 days in excess of 36 hours. They were working really hard. Okay, so yeah, these are ethical issues.
And the issue is, okay, so I've got 10 cases on the docket that day. I spent an hour in court total, but I'm going to bill each case 1 hour. No, you don't. The one you got on, we had the judge signed the order, so we had to pay it, but then we were able to get them on federal wire fraud.
So the first issue is this. Okay, we're sitting around having a discussion in the office, and this is at the time I was at the PDS office with Jack Rogers and Russ Cook, who was the acting director after Jack left. How do we do this? We've got state judges signing these court orders, and one of the ethical issues is, well, I can see that there's a mistake here, so what the office would do is they would just strike it through and say, just reduce it. Well, didn't you modify a court order? Don't you need a judge's signature on that to modify that court order for payment? So there's some of the stuff on the public defender services that was being done, just because it was easier to identify those. The one issue was, hey, so going back to what we were looking at, how do we, call judges out that are state judges? Well, and a couple of us sat around and we thought about it, and I said, well, they mailed these, didn't they? Well, what's that got to do with anything, McKinney? It's mailed. Don't they get in trouble for mail? And they're like, yeah, it's only about wait a minute. So the first thing that was done is the filing. So the individual was from Martinsburg, and they were charged with 99 counts of mail fraud, 12 counts of wire fraud, and 1 count of conspiracy. And they decided that they didn't need to show up for court, so they're in prison. So that's kind of scary.
And there's a reimbursement order part of that, and doesn't
yes.
You tell me that the federal prison docks their pay and sends a check to PDS?
Well, there was a restitution order, and so suddenly I got this check in the mail from the Bureau of Public Debt, and I'm like, why are we getting a check from the Bureau of Public Debt? $7,500. So I call, and they laugh, and they said, we'll get back with you. I'm like, why are you laughing? I'm just trying to call about a check. Well, apparently they entered an order for her prison wages and garnished them at 20%. So you get a quarter an hour at the time. And they had this clause that they said excessive rate retainage that said anything over $15 in the client's trust account that the IRS would sweep. So the IRS was actually collecting the money and submitting it to us, which was kind of crazy. So her husband would send her a check, $100, and since it was over $15, all that money was considered excess retainage and take it. So she really upset the federal judge.
And then I think my favorite story you were telling me dealt with conflicts of interest. Attorneys as witnesses to crimes.
Oh.
Yeah.
Okay, I got to tell that story. We held a public defender conference in Charleston at Embassy Suites. So Jack Rogers was driving a car. This guy rolls across the hood of his car. He was late, so he was, kind of slow trying to park. And he starts to yell at him, but he noticed he had a gun. So he apparently just robbed the United Bank building in Charleston. He goes through the Embassy Suites kitchen, so there's money flying everywhere because he's running through there. And he passes Menace Ketchum and Judge Spalding at the public defender conference. So they tackle him at there, and we have to delay the conference for about 15 to 20 minutes. Now, the first thing that people started laughing is, wait a minute, who's going to represent him? Because guess what? Everybody's here. All the public defender's office, the appointed counsel, the judges. I mean, at that point in time, what do you do? Because the cops are like, we're going to need all your names.
So do you kick it up to federal court because it's a bank robbery? Well, the folks in the same system are doing the work in both state and federal court. So that was, yeah.
So, I mean, what do you do at that point in time? So it's little things like that that are kind of interesting, but that sometimes we don't account for. And, that's part of the difficulty sometimes.
Beyond reimbursement issues and conflict of interest issues, do you see any other structural issues or other problems that you've identified in the system that you'd like to highlight?
Again, I think competency and expertise. We've got those ethical obligations that we are not supposed to take on cases that we are not qualified to take on. West Virginia is better about this. Once upon a time, all attorneys in West Virginia could be randomly appointed to represent indigent defendants, whether or not you knew the first thing about criminal law. A guy I used to work with told me a story. He was fresh into the bar, and he does real estate law. Fresh into the bar, hadn't even received his certificate yet, and he gets appointed counsel for this guy. So he drives up to meet the guy, and the guy won't talk to him. He wants proof. Again, this is the suspicion of government that's kind of ingrained in all of us. He wants proof that this guy is an attorney before he'll talk to him. So the guy I worked with he just happened to take his buddy with him, who literally had his law diploma framed just then, that they'd stopped on the way at the framing shop to pick up, had it with him in the car, and the indigent defendant said, okay, he's got his law diploma, that's good enough for me. He's my lawyer, not you. We're not there anymore, which is good. We do still have, it's a voluntary system. You don't have to be appointed attorneys, but I do think those competency and expertise issues are still there to an extent. And again, it's just a matter of the market. Your best attorneys aren't going to be doing the work for $80 an hour.
I think the payment issue is one issue. I also look at when you're talking about the structural changes. The Indigent Defense Commission, the chair of that is the Executive Director of Public Defender Services. Potentially reworking the Indigent Defense Commission to have its own chair, to take more of an active role, to potentially expand the membership on that commission. The reason that the public defender corporations were put into place was a requirement from the local support system, from the county bars, the county commissioners, to get involved. And I think that there's a possibility through home rule that we can actually create robust offices that are holistic offices within Morgantown or Charleston that look more beyond the need for criminal representation, that looks at the other ailments and society issues that may be impacting the person's quality of life, or that could be barriers. Because sometimes if you've got employment barriers, you get desperate. Okay, sometimes when your kids are hungry, you get desperate, and sometimes we have to think like a client, so to speak, and put ourselves and say, well, I'll never do that. Well, never say never. Right. It's possible.
And even if you don't do it, doesn't mean you can't be accused of doing it.
Yes. Yes. In Florida, the public defenders are actually elected. They're not salaried. They're salaried, but they're elected offices, just like the prosecutor. So, and in discussing with those individuals, how did you get elected? And they said, well, we can't say that we represent criminals. What we have to say is, if your constitutional rights are violated, we have a minimum standard that is protection of constitutional rights for everybody, and you would want representation if you're accused. So that's kind of an interesting stance of, hey, I'm a public defender and I'm elected.
You spoke about modifying the commission and then what they do in other states, but are there any improvements that you two would recommend to respond to the ethical violations that you discussed, or any of those other structural issues?
With some of the billing schemes, that's been corrected through the 2010 legislation that has 90 days from the date of service. The online voucher system, so you have an electronic system now that people are putting in their funding and their billable hours, so that also triggers an expectation so we can actually reasonably estimate what the amount is for the need for an appropriation request is. What would be very helpful, again, if we're using this online voucher system, I'm looking at apps like Uber and what happens when you get an Uber? You're charged. What happens if you do Grubhub or some of the other apps? You're charged. How come as an attorney, I'm not an attorney, but as an attorney of an appointed counsel system, how come they can't get payment periodically? And that, I think, would alleviate some of the issues. The other issue that we have is some cases, most often these people were inflating the numbers by about 30% because they were factoring their claims and assigning them to other places to get the money now, because that's how they had to operate. You know, you've got salaries that you've got to pay and waiting for a check from the government. When are you going to get that?
And I think too, just from a little bit broader perspective, it's again shifting the mindset on this from we're representing criminals to we're guaranteeing everybody's basic fundamental constitutional rights. That is a more popular political sell. Who here doesn't like their constitutional rights? Right? Who here loves their constitutional rights? Yes. Now we know that because we're in the legal industry, and you go out in the street. But I talked about this with undergrad business students. Everybody loves their constitutional rights. I think if you can shift that focus, not only do you get more, I think, voters into that, I think you would get more lawyers interested in doing criminal indigent defense. It's not about defending the accused, it's about guaranteeing rights. And again, that raises that issues of competency because people get passionate about these things. And identifying those people who are really, truly passionate about liberty and rights and constitutional guarantees goes a long way in assuring that minimum. We ought to assure more than the minimum. We ought to assure quality representation, no matter what the setting is. And that's true for indigent criminal defense as well as it is for Fortune 500 companies.
So that's all about modifications and changes you would recommend to the current system, but how would you structure and fund the ideal public defender system? Would it be the West Virginia system? Would it be a state system entirely, or involve an element of local control?
I hate thinking about ideals for two reasons. Number one, it's a whole lot easier to identify what's wrong with the way things operate than it is to identify what's right with the way things operate. Sorry. So that's a practical issue. The other thing is we also don't want the perfect to be the enemy of the good. So can we make steps towards progress rather than the ideal? So what are some good ideas that might help us get better as opposed to what's perfect? I really think the Florida elected public defender system is a real interesting thought. We elect county prosecutors. Why don't we elect the defense attorneys too? And then again, some of the funding models. You go back to we talked about Germany, which is and Ralph was telling me this, and I'm going through my mind like, okay, so what are the economic incentives here that folks are gonna just raise Cain about if their insurance premiums go up, and how much money are people willing to pay for a guarantee of their basic fundamental rights? And I would hope that people are willing to pay for that. It's a shared responsibility, I think. We are looking for a more perfect union. So again, those are some ideas. I don't know that I know what the ideal is, though.
Well, let me expand that a little further. I like the way the West Virginia Public Defender system is set up because it does have a presence at the Capitol complex and could advocate. So from a state broad policy perspective, I think that they should be able to establish minimum requirements. And where the home rule would be beneficial is the local municipality or the local government could actually create and structure some of these organizations or activate them and run them as holistic offices and bundle the perhaps legal aid processes, maybe some civil rights attorneys, because sometimes a person that may be accused, there may be multiple issues with that case. So it could be civil rights violations. It could be other issues that are not being solved. And I think if we bundle those, then we could actually have an economy of scale. Looking at Workforce West Virginia, some of the grants for education and training could provide individuals with skill sets so that they can become employable. So maybe as they're being accused of the crime and they're going through the process, they're also receiving maybe public assistance, maybe they're getting some skill set training so that they can advance in their career, or if they don't have a career, that they can become gainfully employed. As I'm gonna pick on Jack Rogers, and he said this best. He said, if I can eliminate poverty, child abuse, alcoholism, and substance abuse, we may not be talking about some of these issues.
Before I open up for questions, would either of you like to share anything else with our audience?
What do you got? Anything?
Covered it all?
I think we covered everything,
Okay.
yeah.
Are there any questions?
Coming from a municipal attorney's perspective, who has limited finances for our office, funded through our local governments, versus the state funding that public defenders have, and the time that we spend, when you talk about the cases, there's usually one municipal attorney on the prosecution side with a myriad of other representation within the room, including several people from the public defender's office. I just wonder how, when you talk about the holistic and municipal governments taking on some type of an extra burden for social services, which are usually filled within, say, a community development department, et cetera. How do you justify that? Because the public funds in the municipality are solely relied upon to pay municipal attorneys to prosecute on behalf of the local government and the police departments. And when you talk about $60 and $80, that sounds pretty good to a full-time municipal attorney, because that's not on our paychecks.
Right, and I understand that. And when you're looking at the $60 and $80 rate, that actually is including overhead, insurance, pension, and all the other benefits that are tied into that. So the people that are appointed counsel, they don't get any benefits. So those rates are what it should cost their law operations to function. So that's where those rates come into place. So when you're looking at the shared governance, there are local support and sometimes nonprofits, churches help sometimes with the food. So maybe having, each municipality can choose how involved they get, and I think that becomes a community issue. In some cases, you could potentially apply for block grants for opioid epidemics and treatment. You could talk to churches about providing counseling. So I think the municipality would be the one to foster items under an umbrella that they would have a lot of bridges built so that they can reach out across those bridges for the holistic services. So I don't think necessarily it would be a super burden on the municipalities. Yes, there's going to be some extra work involved, because with any type of relationships, we have to cultivate it, we have to build trust. But I think it would be more of a stable environment, because in some cases when you have a public defender office within the county, people know that that's there. And even if they have a legal question or have some issues, they sometimes stop in and have a conversation. And I think that's what you want. You want to be able to have a presence within the community to have the conversation to make sure that people are doing the right things.
And just add a different thought. The Ohio model, because I'm practicing Ohio as well. There's a statutory mandate in Ohio that if you have a public defender office in a county, it has to be funded at the exact, well, not the exact same, at a comparable level to the county prosecutor. If you have one. If you have one. There's no mandate to have one. So what you have are a lot of counties that just don't have a public defender office because they don't want to fund that public defender office at the same level as the prosecutor.
Great question, focusing on the municipality. Is there another question?
There we go. Hi, thank you for coming. So kind of on that same line of reasoning of like comparing how much money the prosecutor spends or how much law enforcement spends versus the amount of money that is allocated for public defending, and also in sort of that decriminalizing certain drug offenses. You know, it's like if we're criminalizing things that maybe shouldn't be criminalized, you're going to put public defenders in a difficult situation because if you're spending $100 million on law enforcement and prosecution and you're only spending $50 million on public defending, well then you're in a difficult spot. And so maybe, I'm wondering if you've done any research on the relationship between the amount of money spent on law enforcement and prosecution versus the amount of money spent on public defending, and sort of the second part of that question is like, are we actually reducing crime rate or making people safer by criminalizing some drug offenses or minor crimes? And maybe the solution isn't necessarily to spend more money on public defending, but just reduce the overall money that we're spending on law enforcement when it's really not bringing us any kind of positive outcomes. And I think that goes to your point about tough on crime, this sort of political talking point that people get caught up in, but it's really not making our community safer or better. So I just wanted to get your thoughts on that.
I think that, I have done research looking at the prosecutors as well as the public defenders. Prosecutors are more well-funded than the public defenders' offices as well as services. But they also have to do a lot of the investigation and other things than the public defender. So I can see where that may be needed. The question with the criminal activity, and are we basically attaching jail time for things that we shouldn't? Yes, I think that there's some issues that maybe if we look at our criminal statutes, we need to reduce, or maybe we need to focus on community services, because once a person is incarcerated, that changes their social groups that they identify with. And in some cases, if you look at organizational behavior and social identity and organizational identity, on all those concepts, when we're around people, we start to pick up the traits, we start to understand the jargon, the lingo, and I think sometimes that putting people for those minor infractions into a prison system actually creates a better opportunity for them to be successful and upgrade their skill sets. So maybe it's the community service that's needed, or maybe some of these issues that we've got attached to criminal penalties may not necessarily be needed. So does that answer your question?
And I think, again, that goes back to the local nature of some of these problems, and maybe the answer needs to be local, not state-driven. And I think a great example of that are our drug courts. Our drug courts have been hugely successful in removing folks from the criminal system, getting them back on a path towards being a productive member of society. I think that's a model we really need to spend some time looking at and seeing, can we extend these concepts to other areas, other social ills that are feeding into this criminal cycle.
And to add on to that, when you're looking at a drug court, you have representation from the prosecutors, from the public defenders, and they're all working in conjunction. And when the first drug courts came out, one of the biggest arguments that Public Defender Services had was the fact that, wait a minute, we've got public defenders that potentially may be asking for jail time for their client. That's a conflict of interest. So how do we mitigate that? How do we get involved in that? Do we show up? Do we not show up? And I think the drug courts were an innovative idea, and they're very successful, as Casey pointed out. And I think that's a new, innovative way of thinking to tackle the problem as a social problem and go beyond that. And most of the drug courts are really local endeavors.
Mm-hmm.
Thought-provoking, thank you. Is there another question? If you'll
Hi.
wait for the microphone.
Yes.
Oh, there we go.
Hi. Mr. Baker, you had mentioned that the state used to have a mandatory appointments list
Yes.
for criminal appointments. Monongalia County tried something similar with a court order that required anyone practicing in the county for its first 2 years to do mandatory misdemeanors. And this has been a part of an ongoing conversation about putting a public defender's office in Monongalia County, and I think the discussion is still happening, but I'd be interested in hearing you guys' thoughts on whether an appointment list versus a public defender is a good use of local involvement.
I have 13th Amendment concerns about compulsory representation. I don't want a lawyer who doesn't want to be the lawyer for the client. That's not going to incentivize quality representation. If you're a lawyer, you need to be involved in that case because you want to be involved in that case. I would much rather spend that time and energy in the debate fostering passion for the issue as opposed to compulsory participation in it. If that answers your question. That's my perspective. Not my opinion, my perspective.
Do you have any thoughts on that?
Yeah, I like the idea of, if you're going to have a list, it's got to be voluntary.
Yeah.
The other thing that attaches to the list is not just the fact that they're able to practice law, but what areas are their expertise. Because in some cases, you may have somebody that is great at traffic violations, but doesn't know anything about murder charges. And then you have some people that may be able to do capital offense, but not traffic violations. So again, the expertise is going to be important so that we can appropriately match the attorney with the client. And in some cases, you actually have to talk to that client because personalities are slightly different sometimes, and some clients do not want certain people representing. I don't trust you because I've never seen any proof, therefore you're not what I expect. So there's those issues as well. And I think that in some cases with the applications, we have to look at the accessibility of a client. So we sometimes have clients that are deaf or blind or people with disabilities, and understanding that they have special needs, and maybe some people don't acclimate well going to certain buildings, and maybe they have to be visited at home. So having, again, the right fit is important.
We have a question up here at the front.
Yeah. Many cities in West Virginia made the decision to not bring charges in the city courts for misdemeanor offenses, but rather the decision is to put those off to magistrate court. Based upon home rule, do you think that that's an appropriate decision to be made by a city? Or do you think that that's them giving up their responsibility?
I think, and again, it's resources. Why am I going to spend city resources when I can punt this to the magistrate courts and let them spend their time and energy and resources? That's the justification there. But, and again, it's shifting the mindset here from I'm spending resources defending the accused or prosecuting the accused into a mindset of I'm solving I'm working on one part of a larger social problem. Typically, I think municipalities want to solve the problems of the municipality. Understanding that this is part of it requires their involvement, especially as you consider home rule. What do you think?
Well, to address the issue associated with taking a municipal, and I think you're delegating that work
Yeah.
to the county, and that's perfectly acceptable. And I think that that's part of the building relationships, because in some cases, you have some cities that their city attorney is a volunteer and a real estate attorney, or I can draft a contract. I don't know criminal law, so why do I get involved in that? And I think that's where the partnerships come in, and the city determines what its course of action is. So the municipality does and says, you know, what we're going to do is we're going to delegate everything to the county to prosecute and take care of, because what we like to do is specialize. And when we specialize, we're able to do things that are great and exciting, and our performance increases. And I think that's through specialization, what you have to do is realize that you have weaknesses and you can't tackle everything, and identifying the other people that have strengths, such as maybe the county, because that's what the prosecutor does. And delegating that to the county allows you to focus on maybe some of the economic development incentives, maybe some of the other problems that you have within the community. You know, energy management, things like that become really important. And I think that in some cases may be the best decision that you can make.
If you put that requirement on the cities, would you then say that it would be the state's responsibility to reimburse the cities for that? Because as we know that fines and court costs don't stay in the city level, they go to the state. And so you're imposing a requirement upon a city to prosecute these cases. And of course, as we all know, not every criminal case in West Virginia gets a court-appointed lawyer.
Correct.
And maybe that's a flaw in the system, since everything that's a violation of statute is a misdemeanor in West Virginia, whereas other states like Maryland, District of Columbia have different requirements, have offenses or citations. Also, if you go to the District of Columbia, you're not entitled to a court-appointed attorney unless you're facing up to 90 days in jail. Whereas in West Virginia, if there's any jail time, any possible jail time, you're entitled to a court-appointed counsel. But like I said, if you put the requirement upon the cities, shouldn't we get some of the fees back?
To answer that, I will say this. In Charleston, the Kanawha County, which is the 13th Judicial Circuit Public Defender Corporation, actually assigns a public defender to the county, and so or to the city of Charleston for municipal court. So that's actually being paid for through the state funds. In the current version of the West Virginia Code 2921, it does allow any organization that is seeking indigent representation or wants to do that to actually file for a grant. So in some cases, your municipality can say, well, we'd like to have a public defender for our municipality, and we will file with the West Virginia Public Defender Services a grant application requesting that the position be funded at this and the rates be funded at so-and-so, and they can actually, you can sketch out a budget and say, this is what we'd like to do. This is our proposal. And that actually has to be entertained and reviewed as part of their function and their mission. So, you know, it's not, so the answer is yes, you could probably seek additional money. I can't guarantee what the administration would do, but that is an avenue to assist with some of those issues.
Thank you. Here at the front.
Can you talk about what, if any, role the Public Defender's Office has in lobbying to help decriminalize some of these jail-related offenses, so that it seems to me that you would have the factual details to be able to talk about what the financial repercussions are of the level that you're having to fend these types of crimes?
So what we did is we always looked at the financial. That was kind of the most important things for the legislature. How much is this going to cost? So the financial information is there. Anytime that there's a bill that has a criminal penalty or modification, there's always a financial note placed within that that comes from Public Defender Services. And in some cases, we started expanding those financial notes to include other information that says, this is going to tax for jail time. There are other issues outside of the finances that we have to consider. So there's those points. The annual report is another tool that was made public and put on the website when I was there. One of the items that we wanted to do is create a more transparent office. So by making things available on the web, we were also able to lobby the legislature. And I can tell you that from the executive director, Jack Rogers, when I would not see him for 2 months. So during the legislature, he was having lunch with everybody. Okay, he was doing everything that he could to lobby. What was an interesting story is occasionally I'd have to go with him with the meetings, and the first thing he told me is, he goes, "McKinney, don't wear a suit." I said, "What?" He goes, "Don't wear a suit. I want you in a golf shirt or something relaxed, and you're not sitting with me when we go to these meetings. You're sitting on the other end of the room, and you're not taking pens or paper or anything like that, because I need you to listen. And when I leave, you're going to leave a half an hour later, because I need you to understand what's going on in the room, what they're talking about, what they're complaining about after I leave, because that's when the discussions occur." And having that was actually a wonderful strategy, because I was able to go back and say, these are the issues that they're talking about. And then the next day, he would go visit those people that are identified, because I had to study who was elected, who's sitting here, and take all that here. He would meet them and say, "Hey, I'm treating you to lunch. Let's have a discussion about the issue that I heard that you may have raised." And because I was sitting in the corner, nobody looked at me. Because I didn't have a suit, nobody looked at me. The other thing he said is, since we're asking for more money, don't look like we have any money.
Well, and you've got some tangible results out of that too. I mean, your 2009 report was the basis for a lot of the reforms that happened through the legislature, right?
Yes. I did an economic analysis in 2009, which was part of the Indigent Defense Commission report, that actually got the increase for the attorneys. Subsequently, the 4th Judicial Circuit in Parkersburg was formed, and I did all the financial stuff and projections for the offices years in advance, even 5-year plans, 10-year plans. So the reports that they're using still are based on the stuff that we had done. The prosecution for billing schemes was actually started in the office and allowed transferred to basically the U.S. attorney, and we showed those individuals how to do the analysis. So because it was more of a conflict of interest if we were doing and trying to prosecute people for billing schemes than it would be for the U.S. attorney. So
It's an interesting partnership.
So some of the ethical issues is like we probably shouldn't be doing this and testifying as witnesses, since we're also representing the other people. So.
Is there another question from an audience member?
Hi. I've only seen this done in one county, but I'm trying to think of ways that we can save money for the state or put money back in to the state coffers in order to pay appointed attorneys. But in Marion County, at the end of a criminal matter, the 2 circuit judges, they require that all defendants that have appointed counsel pay their attorney's fees, and it's included in their court costs and fines. And I mean, it doesn't affect the appointed counsel's pay; they get paid, but then that client, it's a part of their court costs that they have to pay back all attorney's fees. So that's the only county I know that does that, and I didn't know if any other counties do that, and if that actually helps, if those people if they do even pay that.
To answer that, I think Marion County is the only one that may do that. I have some concerns for that. For example, if you're indigent and you can't afford to pay anyway, there were some bills that were talking about paying a co-payment for court counsel. So if you're indigent, what we need you to do is pay $20 or $25. Well, I don't have that. Well, you don't get a lawyer. So I think that up front, was defeated on that purpose for the right to counsel, the restitution and the payment would probably most likely go to the county, which may be transferred to either the county coffers or to some other issue, okay? And so my concern is, are we doing that and damaging the client economically, or is there another alternative? Instead of maybe assessing money, we can make the community service more of an option. We can have them discuss some of their issues. We can have them do certain work. What was interesting is Raleigh County, at one point in time, they would go through and pick people that had specific skills. So if they had a plumber or a craftsman, those are the people that they would actually target for community service because they had crumbling buildings and a way to get some of the stuff done, which is kind of an odd way to do it. But how can the people actually contribute and get experience and become a part of the community? And I think sometimes what we do is if we find people that can't afford it, what we're doing is pushing them outside the community and kind of ostracizing them.
Professor Baker?
I'd really like to see how that policy is structured before commenting on it too much. But yeah, I've got some concerns there. If we're making indigent defendants pay for the cost of their defense on the back end, that will give you the defense, but then you've got to pay for it even though you didn't have money to pay for the defense. That I'd like to look at that before, because that raises some concern. Like there was actually an application fee at one point in time, right before
they tried, but it was
defeated. So
it was defeated.
Is this just a way of masking an application fee? But we're just not going to charge you the fee until the case is over. I don't know. I'd be curious to look at that.
Any other questions? Yes.
Sorry. I just want to bring this up so I can tell my dad later. He's been practicing as a criminal defense attorney for as long as I've been alive. And he complains about there being no investigation into a client's actual financial background, that when they fill out the financial affidavit, you look through and it's just zeros on everything, and they sign off and the magistrate signs off, and and we get clients appointed to us that have jobs and have money, but they just fill zeros out on the financial affidavit. And he thought that if there was some investigation done, maybe we would require those people to actually pay for their counsel because they do have a job and make money, and that would save the state some money in the long run. But I just was wondering maybe what your thoughts were on investigating the actual financial background and investigating the affidavits and make sure they're telling the truth on those affidavits.
Well, the application was recently revised, and it does have check marks for income, food stamps, and other related. How are you meeting everything? Because if you have zero income, how are you meeting your incidental needs? And I think that I proposed this several times, was if you're looking at an indigent, to determine indigency, there's some of the easier tests. If they're eligible for food stamps or Medicaid, it's pretty much the same guidelines or similar guidelines. So you should be able to give them a waiver for that. If they are working and there's a job and they didn't disclose, then maybe there's on the new application, it does say this can be charged. You can be charged for criminal activity for that. So could you get restitution from that? Yes, I think you're absolutely right. If they don't meet the qualifying guidelines, then you can ask for restitution. Are there investigations into that? Again, the resources aren't there. It's supposed to be, if there is a public defender office or the magistrate office, they should be able to look into those items. If you had a holistic office, then you can actually tie in. If you're making the application, you also have to make an application to the DHHR, which does have the resources, and they can actually use their systems and cross-match with Social Security records and employment records and other things. Is there a central database that perhaps we could create that allows us to do the cross-matching with workforce, with Bureau of Employment Programs, those agencies, to determine if wages are available? So there are areas that we can explore, yes. At present, again, the investigative items, it's really not on the table because they're working on other larger issues, and that's why I think sometimes in the local community it may be a better addressed by a local decision to actually focus on that. And maybe that's what Marion County is doing with the restitution. Okay, you've got an attorney, however, what you've done is you've got a job and you didn't disclose, so we're going to make you pay all this money back. So.
And then maybe this is a good segue into the consumer panel. I kind of Fair Credit Reporting Act light bulb went off in my head. If I'm doing a financial investigation into a person and making an adverse decision based on, I'm denying you counsel based on my investigation into your financial standing, does that trigger certain Fair Credit Reporting Act obligations on behalf of the local court? And I don't know, I'd have to look at, anybody know, top of their head, Fair Credit Reporting Act inside and out? It's been a while since I've looked at that one. I don't even know if county governments would be subject to the Fair Credit Reporting Act or the court system. But if so, yeah, to me that's obviously you want to control for folks who are taking advantage of the system, defrauding the system, but I don't know that you can deny counsel to someone just on the basis of they lied on their form.
With that, is there any last quick question? I think we have time for one more. No? Okay, thank you. Please join me in thanking Professors McKinney and Baker.
Yes, thank you to our panel. I do want to just have a few quick announcements. We're going to have about a 20-minute break. You guys can grab more food and coffee out in the hallway. If you are here for CLE credit, you do need to check in with Lauren at the CLE table. And we're going to keep announcing this throughout the day, but before you leave, you also need to check back in with the CLE table. So we will start the consumer panel in about 20 minutes.
Thank you.
Thank you very much. Pleasure.
Nice.
I know. How we doing? We're good. The featured speaker for this afternoon, like just out her PowerPoint during lunch.
I mean, she can throw it on this computer.
Yeah,
I'm gonna be kind of
I
tied
know
up
you
in
would be
there.
over there, but we can come over and help.
Yeah.
That panel on the wall just pulls the screen
Yeah,
down.
yeah,
and
yeah.
It's just operating off of this computer, like it's already hooked up and
Yeah.
everything. Okay, then I can deal with that. That's okay.
Yeah.
I just want to make sure that that is how this system worked. And
Yeah, yeah. Just hit start presentation, laptop send to all.
Okay.
And that should be good to go.
Perfect. Thank you.
So about this panel, how many people we got? Okay. I will go set up the other room and hopefully we'll figure that out shortly.
Are we set on the agendas for today? No.
Is that fine? We have 5 and a moderator, and he's gonna stand.
Okay.
And he likes to read, so.
That's fine.
Can you hear okay on the live stream?
Yeah, everything's going well.
Thank you. Hey, the speaker. Okay. So, because it's live stream,
Yes.
make sure you find a mic. I know.
Yeah, no,
Kind of annoying. And then Austin and I will run mics for Q&A.
Oh, good.
If you want us to, and if not, you can.
Yeah, I want to. Okay,
Do you
I
want
can
us
do
to
it.
run mics?
No, I'll do it.
Okay, cool.
So what do I have to do? That's off. That's mine.
This is on.
Okay.
All
That's
of
on
these
at all time.
Yeah. And then
Are you getting any feedback with this being on close to that?
we haven't had it on yet.
Okay.
We did have one speaker walking around earlier or yesterday, and it wasn't a problem.
Okay.
Yeah, if you switch to that one, I can mute that one.
Yeah. Let's. I'm just trying to think with the best. I'll probably start here, and then I might move somewhere else.
Right, just turn that microphone on and take it with you.
Okay.
It does take like 3 seconds.
Okay.
And then we have Jennifer.
Mhm.
Not Damien. Lauren.
Yeah.
And Ryan.
Yes. Right. And then I'm supposed to introduce everybody. Well, sort of. I have something I'm going to do. It's a little bit different. Because basically, okay. I think it is. It's interesting to me. Oh, Mexico? Yeah.
How are you? Good, how are you? All right, thank you for coming up. How was the drive? It was okay. It was kind of about half an hour. It is. Put any salt down between Bridges and for sure. But the rest of it was fine. Good. How are you, sir? Well, we planned for everything, and then we woke up yesterday and then snowed. Yes. Hi, Ryan. You were like 2 hands, man. You're all over the place.
Got it. Well, hey, I want to, let me cover something with you guys real quickly. Jennifer's not here. I'll speak for her when she gets here.
Which I'm pretty sure he did not do by going and getting a loan. Right? And so, kind of looking at there, reported that to our GRC today this morning. A little salty about it. What's your interesting thing? Yeah, hardest question to oh yeah. Can you right here you're either self-employed. Starting out with much deeper.
I got like a little like to see what they were trying to do. I got this like, hey, how are you? Good. Hey, Ted Wagner. Nice to meet you. See you. Tuesday or on Tuesday, so took advantage of that. I thought we were having Kevin.
I am a late substitute for Kevin. We were planning to see that an unavoidable meeting, but
It wasn't bad. No, it wasn't bad.
TAR's trying to take out that provision of partnering with the bank in the fintech bill.
What?
That guy is killing me. He's trying to take out the provision about partnering with the bank in the fintech bill.
like, who's in charge of you? You guys know what I'm talking about. I don't have to do anything. Yeah, I love that.
available.
Consumer law and the challenges that transition poses, and the model that author articulated was one of empowering for cities to be involved more as information providers as well as information aggregators. Well, let's go ahead and get started. It's 10:40. My name is Jonathan Marshall. I'm the director of the Center for Consumer Law and Education here at WVU. I'm also a practicing lawyer. The topic of today's panel discussion is related to home rule, specifically in the context of consumer protection. And so people always ask me, well, what is consumer protection? I take an expansive view of consumer protection. Consumer protection is about as wide as the ocean and about as deep. And it ranges from typical things that you would think in terms of consumer protection, debt collection, privacy issues, landlord-tenant relationships. It deals with products, it deals with services, and it deals with a whole host of other things. And so the concept here is to talk about what cities can do, are doing, ought to do when it comes to protecting consumers in those cities, and the tensions that arise. And there are a lot of tensions. In the banking world, for instance, we have preemption, right? Federal, state preemption as it pertains to interest rate caps and things of that nature. But I think privacy also is kind of an interesting, though, case study as it pertains to consumer protection, especially in this context of what cities are doing or ought not to possibly be doing. But with respect to privacy right now, there's two fundamental questions that are being addressed by regulators in all sorts of ilk, whether it's Congress or state legislators or even cities. And that is, what happens or how ought data be stored and used, and what type of disclosures need to come with that, and then what should happen if that information is stolen or taken. You've got like 8 different bills pending in Congress right now trying to address that question. You've seen what California did with passing its own Data Privacy Act. Cities are passing their own data security acts, and the city of Chicago just passed an ordinance dealing with it. And it's kind of an interesting discussion because essentially you have all these different regulatory regimes that are popping up, right? So that causes some inefficiency, but you've also got a situation which you've got to address this situation, right? I mean, who knows more about you
right? What knows more about you than anything else? It's your phone. Your phone knows so much about you. It knows more about you than your spouse, your best friend. My phone, for instance, knows when I wake up in the morning because I've got a watch that I wear, and it tracks how I'm sleeping. It knows when I go for a run. It knows who I talk to. It knows that I'm associating and talking to all the folks in this room. And in fact, I'm sure that on my Facebook feed, I'll get, who should you be friends with? Well, probably some people in this room. And so all that information is being shared, and it's going out to a lot of different people. And so again, this privacy context, though, the answers are difficult. And what you're seeing, though, is Congress has an agenda that's like 10 years old, right? And sometimes state legislatures are not any better. So they're regulating with pen and paper, bits and bytes and 24/7 access, and they can't keep up. So perhaps cities, maybe there's a role for them. But these are the types of tensions that exist in this space. And so the general format is we're going to try to answer 3 questions. The is, meaning what's happening now, right? The want, what do we want to do? And then finally the question of should, what should we do? And the idea is to open up the discussion and talk about some concrete steps or some concrete roles that we could see cities playing in this very important arena. To help me do that, I've got a panel of 5 really wonderful people. I told them that I don't like introductions. I don't like being personally introduced, and I don't like to introduce other people. Their information is available online, but just very briefly. And I've also asked them I have a special request too. So I'm going to introduce them very briefly, but then they have the obligation, and I'll start by telling you something about themselves that's interesting. It doesn't have to have anything to do with this particular discussion or not. But so immediately to my right is Jennifer Wagner. Jennifer Wagner is a co-director of Mountain State Justice. Next to her is Kathy Lawson. Kathy is general counsel for the West Virginia Division of Financial Institutions. Next to her is Mark. Mark is counsel at Jackson Kelly and is also was a former CEO and owner of a bank. What was the name of the bank?
Northern Hancock Bank and Trust.
Okay. Ryan Symington is a lawyer at K. Castor and Cheney, is also the city attorney in Morgantown. And then Lauren Allen, who's with the West Virginia Bankers Association, and is also was formerly with the Division of Financial Institutions. And so, one interesting thing about me, it's not covered in my bio, I have crashed no fewer than 2 movie sets. The last movie set that I crashed was in New Orleans. The name of the movie is Night Teeth. It's a thriller, Night Teeth. It's due to be released Netflix next year, I believe. And there's a bar scene, and I should be in it. Maybe. Jennifer?
So I had about 2 minutes warning of coming up with something interesting about myself. I'm not sure I can do it, but I will say that and this is a little bit relevant to this discussion, my first real job after college was working full-time for the New York City Department of Housing Preservation and Development. So I was a former city employee before becoming a lawyer and a consumer advocate.
Well, I don't know how I can follow those. Jonathan, you set the bar high.
Yeah.
I gave you 10 minutes to figure it out.
You did. And it's totally irrelevant. One interesting thing about me, I have a private pilot license with instrument privileges.
Oh,
It's just a lot of fun and makes life interesting and drives my parents crazy.
I'm Mark Mangano, and we'll talk later because I do too. But no, the most interesting thing is that while I practice here in Morgantown, my hometown is Chester, West Virginia, and it is home of the world's largest teapot. And if you need an afternoon activity, you should come to Chester and have your picture taken with it.
This is so good, and I'm so happy to be going towards the end. To follow up on these, I'm right beside 2 pilots, and I like to spend most of my free non-work, non-family time moving around just on 2 feet. So I guess my interesting thing is I've run a Boston Marathon qualifying time. I'm unfortunately not participating this April, but someday I'll be there.
So I have 2 sons, Jackson and Bodie. And years ago, Jackson decided he wanted to get into theater. And so I took him and walked in that day and said, hey, you know, he was auditioning, and I said, hey, what can I do to help? Since that time, I have designed, I think, somewhere around 15 sets for children's theater productions in my spare time. So.
All right, I appreciate that. Okay, so let's go ahead and get started then. I told you that the first thing that we're going to cover was the landscape. So what I'd like to hear from our panelists first about is, what does the landscape look like? What are cities doing in West Virginia? What's happening nationally with respect to regulation of consumer protection issues by cities? And I think what we'll do is, and I'll skip the order back and forth. We're going to start with Jennifer first, and we'll go down the line.
Sure. So to my knowledge, I don't think that any cities are particularly in West Virginia operating a lot, and people feel free to correct me, in the home rule space and consumer protection. I know across the country, especially large cities, are occupying that space in a variety of different ways. Some things that are particularly, we were talking before the panel, and I think there's sort of 3 categories of areas where cities can operate in this space. You know, one is obviously regulatory, where you're talking about ordinances, licensing requirements, zoning, things like that. Another area is enforcement, and then another area is sort of education, tax relief, issues like that that are sort of, I guess, more ephemeral than the regulatory enforcement areas. I mean, I think, to me, one area that's particularly interesting in the regulatory area to think about is cities do have a lot of authority both over their own utility structures and in terms of, and there's a lot of room for consumer protection in terms of local utilities, water boards. There's a whole complex regulatory scheme around utility regulation, but because a lot of those are operated by the local cities, there's some interesting areas for protecting consumers against unlawful shutoffs, and giving proper notices, rate relief issues for low-income consumers, and so forth. In terms of enforcement, there are a lot of cities that have done really interesting work if you have the resources to engage in enforcement. I know the city of Cincinnati went after some banks after the foreclosure crisis for letting foreclosed properties go into decline. There's a lot of, there were some ordinances passed to try to address the same issues, and those were, in some areas, seem to be preempted. But in terms of enforcement, the city has standing to sue Bank of America for foreclosing on a bunch of properties and then not paying property taxes, allowing the properties to fall down, creating a nuisance. There have been really interesting enforcement actions on fair lending, also in the wake of the foreclosure crisis, where I know Memphis and Shelby County, Baltimore, some other areas sued banks, especially Wells Fargo comes to mind, for discriminatory lending practices that then led to foreclosures in predominantly African American communities, which impacted the tax base and gave the city standing to sue. And then I know that recently Atlanta and maybe Cincinnati have gone after some rent-to-own scams or companies that in a sort of class action, well, there have been class actions, and then also the cities have sued because these rent-to-own companies that are large corporations are essentially trying to shift the burden of maintaining property onto low-income people who are also renters, and then foreclosing on them, kicking them out, and bringing in another low-income person. So there are a lot of areas for enforcement actions that I think are really interesting.
So I'm actually look at things from, I guess, the flip side of a lot of what Jennifer looks at, I work in the financial institution regulatory world. So on a daily basis, we deal with and work within a structure where you have an interplay with state and federal law, certainly all of the time. So it would seem to me that certainly one of the challenges that a municipality or a county would face when trying to enact an ordinance in this environment would be, what laws are already out there. Jonathan mentioned specifically preemption. So preemption of state law is vast by the federal government and certainly in the banking arena. So I would really want to look at what kind of interest in particular, especially in the world of financial institutions, is the municipality or local government looking to protect, and is there some kind of gap in the legislation? We're very fortunate, from our perspective, that we have great working relationships with all of the other regulators who work in this space. So we've developed a really a peaceful coexistence. So everyone really respects the long-standing boundaries that have been established. So I think there's probably room to do more. It's just a matter of figuring out how all the parts will work together.
I think Jennifer did a very good job of laying out basically the three options that municipalities have to kind of enter the space. And again, we're talking more broadly than just financial services, which is pretty well tied down, and there isn't a lot of room for maneuvering for municipalities in that area. But it's still challenging because it's an uphill battle to start to bring litigation, and we've seen primarily larger cities with larger budgets, and and there's a critical mass of people to represent getting into that. And also, I think we've seen situations where perhaps there was well-intentioned ordinances enacted, and they didn't expect the backlash. So I think that part of the challenge in doing legislation at the municipal level is maybe lack of resources and lack of perspectives that are on hand to inform the decisions about what's really appropriate. And I think we saw that kind of in the soda, taxing soda in New York. There was the idea was that we were going to fight obesity with that, and it seemed very well intentioned and kind of a neat idea on its surface, but there was a lot of backlash among the people that they were protecting, and certainly at the state level, which led to state legislation to preempt that and take them out of action. In other cities, they attacked it a different way and looked at taxing things like soda and using that specifically for some other social benefit. And that kind of led to the state legislator saying, no, that seems like a decent idea. They didn't go through the front door, they went through the back door. So I think one of the key issues is where municipalities think they have some space, that they really need to think about the political fallout and the political landscape beyond the municipality when they go ahead and implement these things, and have an argument ready for those who may oppose them that is broader than just the solution they chose.
Ryan? I think that's Mark makes some good points about the limitations on municipal action in the state, and particularly with respect to instituting litigation can be a resource issue for municipalities the size we have, and regulating can be difficult with the enabling legislation given to municipalities. But one of the and so because of those things, you don't see a lot of overt regulation in this space by municipalities, at least at this point. And I'm not very familiar with other municipalities pursuing that authority through home rule yet. But one of the avenues mentioned in the article you shared was empowering consumers through, in part, being a collection point and one with credibility for consumers. And I know cities do that because they are close to consumers, and they have code enforcement departments who enforce the state building code, fire marshals who enforce the fire laws, and so interact with people who may have consumer issues. and are able to at least provide information. So our code enforcement department provides some semi-regular seminars on what the building code requires and how compliance can be met. They also maintain records which are public, which show when violations have been found. And I think sometimes to them it's frustrating that they can't revoke a contractor's license, but municipal licensing authority is coextensive with the state, and that's not an option municipalities have. But they can act as that information point, that collection point, and both refer those issues they become aware of to state agencies with the authority to address them, and also inform the local constituents with whom they interact when those issues are common.
Lauren? So I think I would just reiterate, to Mark's point, financial services in general is a super heavily regulated industry, and it has been for a very long time. And there's a very complex regulatory structure, both from the federal regulators and the state regulators, as Kathy pointed out. And so I think it would be very difficult, right, for a municipality to sort of step in, wade into that space, given the existing statutory framework and regulatory framework. And to that extent, as far as just regulatory and passing specific consumer protection type ordinances, one of the things that we've been sort of watching and listening to some conversations about, and this is very specific here in West Virginia, but, and you sort of touched on this, is land use and some of the municipalities, small cities that are dealing with dilapidated and abandoned structures. And I think that there's an interesting intersection there in that particular space for a conversation about consumer protection and how municipal governments act and oversee that type of property within their within their municipal boundaries, and the impact that has on consumers who could be property owners, right, but also consumers who live and work and consume in those communities, and the financial institutions that that are involved on all elements of that, whether it's the actual dilapidated property or adjacent surrounding properties. I think that there's a lot of space there for a conversation in that regard with for consumer protection. So that's something that we've been sort of watching.
Can I just pipe in one thing? In terms of like actual like consumer financial like ordinances and stuff, there are at least some large cities that are on home rule have enacted some that aren't subject to preemption, and what you can't have like an interest rate cap or something like that, but New York City has a Unfair and Deceptive Acts and Practices Act specific to New York City, and there would be some questions potentially about state preemption and how a local ordinance would interact with our state consumer protection law. But my assumption would be that if it is broad and more protective than the state law, and of general applicability, then the a local ordinance could be protective. Then there'd still be a question of the enforcement of that local ordinance. But I don't, I think we will talk a fair amount about preemption, and that in this space that is a major issue. But I think there are areas that are beyond that. And like I said, New York City has its own consumer protection law.
Great. To kind of add to that, in terms of kind of the landscape, I created a little bit of a list. Landlord-tenant issues, right? Right now in West Virginia, there is a case out there that basically holds that the Consumer Credit Protection Act does not apply to landlord-tenant type relationships. It's caused some issues. And there's actually a new law review article out there that addresses some of those issues, and perhaps somebody who's in this room may want to address that a little bit later. Another area is utility purchasing. Cities in Massachusetts, for instance, are buying up utility type credits and then trying to offer more affordable power and other types of services. Broadband access municipalities are getting in the business of offering broadband because they recognize that that's a pretty important service for the city itself and for business owners as well as residents. And so cities are getting in that space. Privacy, I talked about. Health and welfare issues, which I think we talked about. That includes blighted buildings as a result of foreclosure, harmful products, sugary drinks, if you want to consider those harmful products, discrimination, which I think there was some another panel on, and discrimination is a form of consumer protection in the sense that you have certain statutes that prohibit discriminatory decisions as it pertains to making credit decisions. Access to housing is another area. Also, direct litigation. So in West Virginia, what's happening right now? Cities are filing lawsuits against opioid manufacturers and distributors. And so that is also, I believe, a form of consumer protection. So these are kind of some of the landscape, if you will. And one of the other things that Ryan had mentioned was I had circulated an article to this group by Suzanne Block-Lieb, and it dealt with cities as a source of consumer financial empowerment. And her position was that what cities can do is maybe they can't overtly regulate in some areas, but they can be a source of empowerment, meaning they can be information collectors. So for instance, having a database that stores all the complaints about scams that are happening, bad business practices, and make that available to people in the city. They can also be a dissemination provider, meaning hosting essentially talks and workshops so people can maybe better protect themselves as to the particular problems that the city's facing as it pertains to consumer protection. So there's that concept too. And there's debate about that, whether that's a good thing or a bad thing. We can talk about that when we get to want and should. But before we do that, I do want to kind of continue with our discussion about the landscape and talk a little bit about what are some of the challenges that cities face in this space, and also to address the why question. Why ought they do things in this space? And so to do that, to lead off, I think I'm going to start with Mark.
Oh, okay. Are we on why or what?
You can do why and challenges.
Yeah, I think
we're not on want yet. We haven't got to want yet, but I'm just saying, why are cities doing it now? And what are some of the challenges that they face?
Well, I think, again, you have municipalities tend to take action first because they're closer very often to the issue. They can see how it's directly impacting their neighborhoods, their economic development of their communities, and so it's immediate. And so I think there's a drive very often to try to find an immediate solution, and so you scramble to find practical solutions. And that's where I think the challenge comes in, is because it's a minefield. The landscape is there's lots of opportunities for preemption. There is also the political landscape that if it isn't preempted now, basically the home rule is authorized to do pretty much anything that isn't against the Constitution or the general law of West Virginia as it stands now or will be. So you have to always have that on your horizon, that whatever we decide to do may get challenged. And so that's and again, you have limited resources, especially smaller municipalities. How much can you afford to be out there fighting with somebody about whether this rule should stand or not? And so it takes the analysis to a second level. It's what do we want to do? Do we think we have a good solution? But how do we protect this and do it in a way that is not going to break the bank?
Who else wants to address this? This is the why and challenges question. Lauren?
I think one of the things that we talk about a lot in the banking industry is the survival of the community bank model and access. I think Jennifer mentioned this at the beginning of her remarks, is just access to financial services, right? We see more and more banks, small local community banks, just closing up shop, getting purchased and moving out. And I know, there are a number of communities when I was at the Division of Financial Institutions, and even since then, that small towns lose their bank. and you no longer have access to, it's a 25-mile drive to your ATM to get cash on your card, or and so I think that is also a consumer protection issue, right? Is people in the community having access to financial services, and that's, I think, should be part of the equation, right? When municipalities are thinking about educating and protecting consumers and understanding the needs of the community and the people that they serve, I think that's an important factor.
Yeah, I mean, I think in terms of the why, I think a lot of the reason that home rule has a lot of cachet right now is because people who want to actually push the agenda try to increase consumer protections or protections for people broadly, and see that maybe not happening as much on the federal level, and then sometimes not on the state level, want to see if there are ways to push the envelope on the more local level. So I think that there are some, in addition to the reasons that were previously discussed about the proximity and knowledge base in the local level, this sort of maybe different political climates in different municipalities that might have different interests and want to promote different interests on behalf of their citizens. I do think there's some, in terms of tensions, you obviously have the preemption tension, but then there's also, and I think this was discussed a little bit by Mark too, like the potential backlash that if you are trying to, if you're in a municipality that is maybe more progressive than the state, you might end up generating state legislation that is worse than already exists in order to preempt your local legislation. And so I think there's a real tension there about how to do it and what you want to be doing and how you justify it as appropriate for your local municipality, whereas and not appropriate to be bringing up to a statewide agenda. I mean, I think some other issues that have come up in my thinking about this have been, West Virginia, as opposed to some of these other localities that have done really aggressive work. Our geographic boundaries of our cities, of our municipalities, are rather small, and so like take Morgantown for example. If you have put forth a local ordinance that maybe requires special licensing requirements for used car dealers and bonding and is more onerous to make sure to protect consumers from fraudulent, misleading practices with used car dealers, all they have to do is move up to the mile ground where they already are. So they don't, to escape the local boundaries and get out of those requirements. And so by doing that, and I'd be curious about Ryan's thoughts about this, but you end up losing some of your tax base. And so there's a little bit of a conflict there. You might be trying to protect your citizens, but by doing that, all you're doing is locating businesses just outside the city boundary. So I think those are some really interesting questions in terms of whether or not to do this.
Ryan. Yeah, I think Jen puts makes a very compelling point about the challenges for municipalities in regulating this conduct and other conducts in that, because we're a rural state. You don't have the same kind of capacity just through density or through size to govern a real territory. But then that problem perpetuates itself as well, right? Because if you do something that is important to your citizens, but that impacts an industry in such a way that it's inclined to move outside of the boundaries of the city, that impacts the tax base and that impacts the resources the city has to then do other regulation that is important to the citizens. And of course that ties into the first part of that question, why, and the reason is access. That people can go to their city council member and go to their city council meetings easily and raise those concerns. And while other levels of government may have more capacity and more funding to address them, they're not nearly as accessible.
Kathy, you want to add?
Sure, I'll just add on to what was just said about accessibility of local governments for the citizens. So, assuming that local government can get through all of these, hurdles that everyone has already addressed, they probably can also act a little more quickly to address a perceived wrong or a gap in maybe some consumer protection that they've maybe heard their local citizens do want. So by having this smaller governmental entity to deal with, maybe they can move more quickly than we could at the state level, and certainly much more quickly than anyone could at the federal level.
Thank you. So with that said, so you can see, so in terms of the landscape, there's lots of different areas in which cities are now getting involved in consumer protection regulation. And the reason for that, there's lots of different reasons, but I think what you're hearing is a primary reason, of course, is access and flexibility and the ability to do things more quickly and address more current problems. But the drawback is that just what I think Jennifer was talking about, what Ron was talking about, is geographical location, right? So yeah, so you have a great idea. Let's go ahead and maybe have a little more stricter licensing or some bonding requirements on certain types of industries. We'll go to those industries and move out of your city. Okay, well, now you lost a very valuable piece of your tax bracket. So now people get mad about that. And so there are challenges there. There's challenges to resources. You were talking about the UDAP statutes, right? So unfair, deceptive acts or practices. These are pretty common in all states, and it prohibits virtually all sorts of things, but basically lying and cheating and stealing when you're selling goods or services, right? How are you going to enforce that at the municipal level? Now, you have this model with the opioid litigation where cities are actually hiring private lawyers to enforce certain provisions, and so that's also a different or interesting model that's out there. But what I'd like to do now is, in terms of the landscape, is there anybody who has a question or a comment? This is a relatively small group, so I'm going to call the audience. Anybody wants to address anything or have any questions about kind of what's happening now? Sir, in the back, I'll bring you the mic. Well, they have to get you on. They have to get you on the internet, or it didn't happen. So
there's a rumor out there that banks have a duty to consumers to make small loans, to make community development sort of issues, things that would help little people. And it's been a rumor because I've never seen it enforced. I've never seen any kind of monograph or some sort of study as to what those duties are. And since we have bankers on the panel, could you address the requirements of banks to make small loans, to do community development things? And finally, would you think that a city would have standing to file some sort of suit to enforce that?
Mark, do you want to address this one?
I lived in this space for 26 years. So there are a couple of things. One is that you have the Community Reinvestment Act, and that is not so much about small dollar lending. That is more about trying to hold financial institutions accountable for reinvesting the deposit base back in the community where they got it, not just porting, basically taking all the deposits and putting them in some other community. And so that's a fairly complex structure, and there is talk of revisiting that because the landscape is completely different now. Some banks don't even have a physical location anymore, and so that's much more complicated. The concept of small dollar lending has been a big challenge for the regulators as well as the industry. The problem is that because lending has become so commoditized, we have a lot of very efficient systems for a lot of customers, but the people who need small dollar loans tend to be, for a variety of reasons, self-selected higher risk customers, and they are not, strangely, all that profitable. Even at high rates, the administrative costs of a very small loan are gobbled up by the administrative cost of just taking a payment every month and processing those things through and maybe taking collateral. So that's a very challenging area because it's not very profitable to encourage banks to do it. And there are some who do it well, but it's been an operational challenge as much as anything. It's not so much, I think, that banks don't want to do it. They struggle to find a way to do it. that doesn't overly eat up the bottom line. And frankly, it was a focus of my bank, so it's a place near and dear to my heart. But even for us, we kind of had to start to put some lower limits on it just because we couldn't afford to go that low. And that lower limits were $1,500, $2,000, and so things that were smaller than that were a real challenge even for a small community bank. Does that help at all? No? Okay.
Who else wants to address the question? Come on, Kathy. Oh, got another. You want to address the question, or you want to offer another comment? Yep, still asking them.
I'll just say that was an excellent answer by an excellent banker. The banks are making those loans. They are doing that business. But I think, like Mark said, when you evaluate that kind of activity across your entire line of business, I think it is a very difficult thing. And one of the things that we hear time and time again from our bank members across the state are, there's this perception that the banks aren't doing the business, but when you talk to the banks, there's the demand is not there. I mean, and especially in some of the small communities, the demand just isn't there. And they would love to be able to make those loans and love to have those opportunities to invest in the community, and it's just not present. And so I think the real solution is probably a much larger solution about more macroeconomic sort of factors in those communities. But it is happening. And it's, sorry, somebody say something?
No, that was me.
Okay.
I was just going to say really quickly, if anyone's interested in the Community Reinvestment Act, there's some proposed rules on the CRA that are, from my perspective, incredibly harmful and really undermine and not just mine, the perspective of pretty much every consumer advocate in the entire country and housing advocate that are really, really harmful and undermining the purposes of the CRA. So to the extent anyone's interested in community reinvestment of banking and making sure that that happens effectively and meaningfully and that the CRA is appropriately implemented, I would really urge you to Google it, look at some of the comments and submit a comment as they're considering the rules. So that's just a slight plug on that. I would also just, in terms of small dollar lending, I think that there are some, in West Virginia, thankfully, because of some usury caps that are on the state level, we don't have the really predatory and horrific small dollar lending that happens in a lot of other states, that payday loans, stuff like that. But I do think that the city financials, the sort of non-bank institutions, aggressively market and end up a lot in that space, whereas the banks that would probably be giving more favorable or appropriate rates to consumers. I mean, part of the problem is this bank consolidation and the fact that those are leaving the local communities. So I know in some other states there are like credit unions and nonprofit banking institutions that have opened up particularly to provide a more affordable model on the local level and I think just sort of going back a little bit to the topic, there are some ways for municipalities to maybe consider trying to encourage local banking, encourage these credit unions and other models that might provide a better investment in the community than some of these other national non-bank lenders.
Other questions or comments about the landscape? Ma'am? You should introduce yourself too.
Hi, I'm Jenny Brobst. I'm from Southern Illinois University. So I was wondering if you'd be willing to comment a little bit on local taxation and home rule. Because Illinois, for example, municipalities can opt in, and sometimes they don't, because they don't trust their local authorities' use of the coffers. And you might get added layers of taxation that, particularly in a state that has a state budget crisis. And I've noticed some states around the country that also are suffering financially. Sometimes they eye greedily home rule as a way to generate revenue, but the voters themselves are not necessarily trusting of the leadership to handle it well. And what's interesting as well is that when you look at turnover in city councils and the rest, it's sometimes you get the same people in there for a very, very long time. And it's not like particularly smaller communities. And so do you have any thoughts about how to use home rule strategically in such a way that it's used responsibly and there's accountability of the coffers?
That's an easy question. No. Let's tackle that one. Ryan.
That's a great question, and it's a big focus of what the home rule program has involved in West Virginia. Our home rule legislation in its current form specifically allows a 1% sales tax that's administered by the state, and almost unanimously the participating municipalities have enacted those taxes, and I think with community support. Our state's overall tax regime for cities is somewhat unique. We use a business and occupation tax that was devolved from the state onto the cities. And it's one of only 3 states, I believe, that still uses that form. And then municipalities get a small capped increment on the property tax. So a sales tax is a more common and many people think more equitable way to generate revenue for the municipalities. But it is it's circumscribed by the home rule legislation itself, so that cities only have the authority to ask for up to that 1% additional sales tax. There was, in the initial pilot phase of the program, which will be part of the panel this afternoon, there's a proposal by Huntington to enact also an occupation tax that was challenged and never implemented. But it seems that that is both an additional funding mechanism and one that is supported locally by people who are trusting their governments to use that well. Morgantown has just enacted, as a latecomer to this this initiative, but just enacted last year its sales tax, which will go into effect in July, and that accountability is important to people. And so one way that Morgantown and a lot of other communities are dealing with that is to dedicate that revenue to a special revenue fund, so that even if it is flowed through to the general fund, ultimately there is specific accounting for the sales tax revenue and the projects for which it is used.
So I want to move on, and I want to talk about want. So when we're talking about want, the concept here is, if left untethered, meaning from practical considerations, from considerations of preemption and all these legal niceties and things that aren't so nice, what do we want? What would we want cities to do? Because I think it's an important intellectual exercise. Because the idea is, we live obviously within constraints, and we're going to talk about the should in a little bit, which kind of takes into consideration both the practical realities, but I think it's important to understand what is the want here. So this is a hard question, perhaps, but I'd like to have the panelists each address, I'll give you 2 minutes to address the want question. And now, don't look at me like that. I gave you guys some of these questions beforehand, so let's go ahead and address the want for a minute. So we'll start with who? We'll start with Lauren. Want. Or not want, for that matter, too.
Yeah, I mean, I think from the industry perspective, and I mentioned earlier, just the importance of preserving the community bank model would be important. That there is a place in every market for institutions of all different sizes, and they all have their strengths and weaknesses. But the community bank model is particularly important in a state like West Virginia that's very rural and has very small communities. And I think access to local decision making in financial services is important. And as a part of that, I think some of the things that you mentioned, broadband access, right? Development and land use, all those things come into play, and I think those are all important sort of building blocks to getting a municipality to a place where they're doing the best they can do for for consumers within their boundaries. Other than that, I think we want municipalities to probably stay out of the direct regulatory arena. And as I said at the beginning of this, I mean, the banking industry is very heavily regulated. It's a very complex regulatory regime, and there are lots of overlapping regulatory structures. And I think, to have municipalities that lack the expertise and the resources and things like that to enter into that regime really, really would complicate things. That's not to say that the municipalities don't have a place, like I said, in protecting those consumers and for access. But I think that's the big thing, is just protecting the community model and making sure that consumers have access. The local decision-making thing, I think, is important, because I see all the time when we talk even about regulatory issues, or where the bank may have done something wrong or made a mistake, a lot of times just having the relationship in the communities and knowing the people that are involved and the relationship between the banks and their customers is such an important, critical factor in resolving conflicts, resolving disputes, and making sure that consumers' needs are being met. And I think, when you see those types of institutions disappearing, and those services and decision-making being taken out of the communities, I think it becomes much more difficult and much more complicated.
Good. All right, Ryan, you've got the magic wand now. What do you want or not want?
That is a legitimately difficult question. I think our communities clearly are not monolithic, right? And there are certainly people, I encounter a lot in my practice, people wanting more activity by the municipality. There are people who would like a local regulatory scheme and local regulators and enforcement actions to help them. And local government is a community service, and I think people come and just expect that of their government, and are sometimes disappointed if they hear, which they do. We're concerned about this, and we're going to refer this to the Attorney General's office or report this to the contractor licensing board. So I think there's a lot of desire for that, and I recognize that there are other aspects of the community that desire more uniform regulation, more maybe stability among different communities where they necessarily operate at scale. Balancing those. Yeah, well, I represent municipalities and think they're great operators in this space, and I think they do a responsible and good job of acting. And so I think at least the capacity to act is important, and I think that has been something that the Home Rule program has shown.
Okay, Mark?
Well, it would seem that the area that there's opportunity and understanding is really in public health and safety areas. That's probably a place there's probably less preemption and more localized concerns that you can identify and really do something about. I think I do want to make a plug for preemption, because one of the things that we tend to forget. Especially in the financial services area. But what's the social utility of that? Again, we're taking this from the viewpoint of how do we enable home rule, but what's the benefit to our communities of industries that are subject to regulatory schemes that are predictable and, again, across scale? Even though my little community bank only operated in two towns, I operated under a regulatory environment that was predictable, stable, Dodd-Frank. But in any event, it was pretty stable, and so you knew what the rules were, and so you could go out there, create models that you could repeat. You weren't one-offing your decisions every day, and so you could create models that were more efficient, so you could reach more customers at a lower cost. And we sort of take that a bit for granted today. And again, There are parts of our society that are not being adequately reached with financial services. But for the vast majority of the population, access to credit is better and cheaper than it has ever been in the history of the universe. And so, and a lot of that is because of really solid regulatory scheme, and thank you very much to the State Division of Financial Institutions. And that's why we still do have a fairly robust, even though it is a concern that we're losing community banks, we still have a very robust community banking sector because we've had good, stable, predictable regulation. So, and that's the plug for why we should be very careful before we jump in and try to second guess a regulatory scheme, even if we can see a wrong that needs to be righted. There may be some countervailing benefits that we're not taking into account.
All right, Kathy, want or not want?
It depends.
Oh.
I think that, Jennifer and Mark have both, I think, presented, a lot of great ideas for areas that are probably suitable for municipalities and local governments to jump into this arena, particularly if it's an issue that's not addressed elsewhere or that is not really firmly entrenched, established, stable, like financial services industry. But, I go back to that point, identify an interest, that the local government is trying to protect, and is there room in that space for additional consumer protection? We've, touched on access, so there are so many positives that a municipality can bring in attempting to address a concern that they have that exists for their citizens. But I think the only negative I would maybe address is that a lot of work is done online now, not just in financial services. But you also have the challenge, and Jennifer touched on this a bit, of encouraging businesses to locate in your communities. And if you're throwing an additional layer of regulation out there, how much does that discourage an industry or a company from coming into your area?
Fair. Jennifer?
And I know, so everyone's had trouble with this blue sky approach that you're throwing out there because it doesn't really make sense in the context of, like why even talk, it doesn't, whatever. But I will say, I would say, and I think these are actually doable, at least some of them. I guess the issue that Ryan pointed out is from the resource issue. So if you set aside the political landscape and stuff like that, I still think a major problem is resources for these municipal governments to actually do any of this. And I think one way to do that is, I think the enforcement angle does take sort of upfront costs, but then it is likely, if you have good cases against financially solvent companies, that it will bring money back into your community and hopefully fund the enforcement measures going forward. If you can put some of that money back into that enforcement, hiring a lot of cities that are much larger than the ones we have here have units that particularly, what they do is the enforcement. They hire lawyers and who work on that. So I think that would be helpful, and I think one way to do that is to partner with, to bring in, even though it's expensive, to bring in outside firms if you don't have a full-time lawyer to contract with. And I know in some municipalities, there's been partnering with nonprofit organizations as well that are interested in pursuing these cases on a public interest standpoint. And we've actually, Mountain State Justice has in some circumstances represented municipal governments or their subsections in dealing with issues mostly around education, less around, and conflicts potentially between the municipalities and the state. But, I think there are areas to join resources for a common goal there. Some other specific things that I think would be really valuable is, you know, we were talking about UDAP enforcement. If there was additional UDAP authority in a local government, it doesn't have to just be enforceable by a city attorney. You can have a private right of action. And I think to the extent that there's an interest in passing local ordinances that protect the people in that community in particular, but then there's not enough resources to actually enforce them, incorporating a private right of action so that the private bar has the ability to enforce them and act as, you know, and fee shifting statutes so that the private bar can act as private attorneys general, but on the local level, could enable that regime to actually be successful. And those issues, those sort of procedural issues, should not be subject to preemption. Now, there are political, you know, backlash potentially. You know, in terms of identifying what an ordinance would address, I think that a lot of what's been discussed here is the proximity and accessibility of the city government and the ability to hear what's actually happening at the local level that's different than elsewhere. And I think it would be really interesting for cities to engage in consideration of what products and services are being provided within their city limits to the most vulnerable people. So if you target it not at, you know, what are people complaining about broadly speaking, but what are people who are extremely low income? What are people who are dealing with disabilities? What are people who are dealing with language access problems? People who are at a particularly challenging life stage, and I know this might be a sort of incendiary example, but there are discussions sometimes about pregnancy crisis centers which advertise services to pregnant women who are in a challenging situation, and they're run by churches or groups that are anti-abortion and provide very biased counseling services. And some municipalities and some groups have required disclosures on advertisements about crisis pregnancy centers. So, you know, looking at what's happening in the community to people who are at a vulnerable time in their lives or otherwise vulnerable to being taken advantage of, and then what can those municipalities do to address those situations that are really local to them. So pawnbroker, and that aren't otherwise being addressed. Pawnbrokers is something Kathy had brought up before. You know, what's happening here that we need to step into the space of. Couple other really quick things. I would love to see like real financial literacy required in middle and high schools. And I don't think anyone here would disagree with that. But I'd rather, I mean, I think that there's space for that potentially on the local level or regional level, but I would love to see it required on the state level. But maybe that's an area to sort of push forward on a, you know, start on a local level and rise up, because it's not actually, I don't think that there would be a lot of conflict about it. And then also, like someone said, broadband and utility access and regulation, I think, is a really good space for municipalities to work in.
Good, thank you. All right. So I'm going to open up the want question, and in my defense, part of this, and the reason I asked the want question is, I bet you 100 years from now that the discussion we're having right now will not be resolved. This notion of devolution, local control, this is never going to go away. And so while you might have a regulatory system or certain constraints that exist today, they aren't necessarily the type of constraints that exist tomorrow. And part of the really important reason you ask the want question is, how do you create the conditions to achieve the want? Of course, you can't do it now for certain things, right? You couldn't see cities, you know, enacting interest rate rules today, but perhaps at some point in time, maybe that might be something that would be desirable. I'm not saying it is, but I'm just saying. So that's why we asked the want question, I think. But I do actually have, I would like, actually, Emily, I told you that I was going to call on somebody to address the want question, perhaps. And Emily, why don't you introduce yourself and also talk just a couple minutes about your article.
Okay. Hi, I am Emily Kramer. I am a 3L here at WVU Law and on the Law Review. I recently, as in last month, published a law review article on landlord-tenant law in the state of West Virginia. So just a few years ago, we had the Supreme Court rule that the West Virginia Consumer Credit Protection Act did not cover landlord-tenant contracts. And so what the article goes into a lot is it's basically the tenant's fate in the mountain state. What kind of avenues are left for them for protections? What kind of laws we still have that they should rely on and be educated about? And then going towards the more municipal route, what can maybe local communities do? So West Virginia is a vast state, it's mountainous. Some regions are very residential, and then there's Morgantown, which is primarily student body when the school is in session, so it becomes a renter area. So I bring into question the idea of local municipalities looking at their communities and seeing what their residents might need for protections. And this can also go into making sure that residents will stay in the state, so especially in the young population of West Virginia is sometimes leaving. So if you can have more protections for especially a renter population who doesn't have the economic means to purchase a home or anything, you may be able to entice them to stay in the community. So that's kind of what it goes into a little bit.
Thank you. Okay. So we actually have 15 minutes left, I think. 15 minutes left, yes. So I'm gonna, we have a want, a desire, all right. Introduce yourself.
Casey Baker, Marshall University. One of the issues we've been looking at in this area is the emergence and adoption of financial technology, specifically blockchain and cryptocurrency, to the point now where the OCC is offering national bank charters to some of these cryptocurrency firms. What is left for local and state governments to address in terms of the issues that these cryptocurrencies sometimes bring with them? Some of the use by criminal enterprises and things like that.
Kathy.
So I can tell you a little bit about what we do currently. So, and actually, some states have a much broader regulation than we do in West Virginia. So to the extent any of these companies utilize a wallet to hold either fiat currency or cryptocurrency on behalf of someone, and it doesn't have to be a consumer. So the West Virginia law doesn't make a distinction. To the extent there is currency of some sort held in a wallet, there's state regulation as money transmitter. So there are enforcement provisions, bonding provisions, like you would see in any typical financial institution regulatory program. However, if there is not an active wallet and they just have a trading platform, for example, we don't regulate that activity at all. Some states do, however, and some states actually are expanding the reach of their regulation as that industry grows.
Good. All right. Well, I want to get to the should. So I'm going to ask another hard question. So we've talked about the landscape. We've talked about wants, sort of wants. What I would like to talk about now is the should, and understanding resource constraints, understanding regulatory constraints. What should we be doing now? And to kind of set the stage for this, I'm going to have each of our panelists address this question, but you can only pick one thing, a single thing. What would you see? What should cities be doing in this space? Or maybe should not too, but one thing, only one thing. So who wants to go first? One thing, not two, one. Ryan?
Sure, yeah, that counts as volunteering, right? I think this discussion has been great, and the panel is great, and it's enlightening for me to see these other perspectives. So I think the clear thing that emerges that cities should be doing is regulating building conditions under the building code. Those are consumer spaces in many instances, and particularly in Morgantown. Municipalities are the sole enforcers of the state building code in West Virginia. It's a clear space where they have both authority and expertise, and so that's an area where there's clear help that can be provided.
Good. Who wants to go next? Mark.
I don't so much have a thing, I have an
Oh, you
approach.
Okay, you can do
which
an
I'll
approach.
suggest.
One approach.
Okay, but I think the approach that I will suggest plays well, whatever the topic is first really be careful about defining the perceived wrong. Narrowly focus what is it we're really trying to fix. Sometimes we try to address the symptom and not the root problem. And I think making sure that we're attacking the right thing is more likely to lead to a successful remedy. Then carefully consider the existing regulatory and political landscape, and weigh those political considerations. And I think you've done all of those things. Then when you go to craft a solution, you are more likely to be effective and cost effective at the same time in getting it accomplished. And I think you have the additional benefit of taking that steady, quiet, deliberative approach is you may be a leader for the state. Again, as Ryan kind of points out, there may be some things about health and safety and building codes and things like that that may, and I think that has happened, to where those things have come out of municipal deliberations and been adopted by states as a great best practice, which would not have bubbled to the surface in the statewide political process.
That's actually good. I'm glad you actually brought up the approach, because the approach matters, right? So a single approach, that makes sense. All right, who wants to address the should next? Jennifer.
I will. I think, just going off what Mark said, because I kind of agree as to that the approach is what matters more than the topic, because the whole point of this is that the municipalities you want the municipalities to be responding to something that is local and appropriate for that municipality. So saying, something about pawnbrokers is not necessarily going to be the thing for everyone. So I would just say, just to build on the approach that Mark was proposing, which I think is right, is that you want to make sure that you have all of the stakeholders involved in the discussion about what the problems are and what the solutions are, because if and that can sometimes be resource intensive, but sometimes municipalities do also outsource that process. They can hire or collaborate with a nonprofit or a for-profit group that brings together stakeholders. Sometimes that's BS, that it's done as a way to check a box. Obviously, that's not what we're talking about. I think bringing together people in a really meaningful discussion about what exists out there, what the considerations are, so that when you have ordinances passed, that they are actually appropriate. And I'm also not just talking about lobbyists. So just to be clear about that. And then I think the other thing to build on what Mark said is, once you have an ordinance or some sort of regime that addresses a local problem, that to make sure that there are appropriate enforcement mechanisms for that. Because without that enforcement, it's a meaningless prospect. And to think about that enforcement within the context of and the confines of what the resources are of the municipality. So is it self-effectuating? Is it a licensure regime where people have to reapply? Is it something that requires litigation? And if it requires litigation, does it require litigation by the city, or can it be a private right of action by private individuals, and so on and so forth? And then the final plug I would just put in there is what I said before. I would really like to have any of these issues really addressed toward the most vulnerable people in our populations, because that's where the exploitation takes place. So, I think that lens should be on whenever you're evaluating what the real problems are, rather than, rather than just taking everything in the door.
Good. Lauren.
I think I'll just reiterate again. Municipalities should be thinking about availability of services and access, not just for the unbanked and the underbanked, which are important and vulnerable populations, but for every consumer in the community, and even small dollar loans or people who are interested in entrepreneurship. I mean, I think that's a critical part of thinking about the overall health of a consumer populace is access to financial services, and so that should be a factor.
Kathy, you want to make the closing argument?
Sure. I absolutely would reiterate everything that both Mark and Jennifer explained. Really look at what interest you're protecting. Is there room in that area to try to achieve the goal that the local government is trying to set? And even if there maybe is already some comprehensive, both state and federal regulation and enforcement in that area, there may still be opportunities to, we talked about this a little bit before, maybe acting as a conduit to those other resources to help empower your community. So, if someone knows that they can walk into an office and talk to someone in their local government who maybe has a broader access to other information or other resources, and really just serve as a great resource, a direct resource for the local communities.
Great. I appreciate that. So, as I indicated to this group beforehand, this notion of this discussion ending today it's not going to happen, or tomorrow, or 10 years, or probably 50 or 100 years. And if anyone wants to take that bet, I'll take it. This is going to be an ongoing discussion, and as issues arise, there's going to be questions about who is best suited to resolve those issues. And I really appreciate all of our panelists' time addressing my somewhat difficult questions and addressing the is and the want and the should. If there are any other questions or concerns, we still have 5 more minutes. Okay, we've got some folks. Sir?
Thank you. I would bet first that those 2 movies you crashed were Ryan Gosling movies, weren't they? Ladies and gentlemen, the internet commerce has had a significant impact on our world, and particularly on local governments. I mean, I'd like to hear y'all's thoughts on that, specifically like Mr. Symington, your community's passed a municipal sales tax, collecting on internet commerce, sales, and things like that. I'm from Pocahontas County. My county commission passed a very aggressive set of rules and regulations for hotel occupancy tax. And one of the things I built into that was the ability for the assessor, to get whatever software he needed. I'm not real good techie, but whatever software he needed to access the sites like Airbnb and all that, where people were dodging the HOT for the counties. And we've really expanded our collections in hotel occupancy tax by going that route. And there's got to be a lot of other things out there that you all have thought about, and how internet commerce is affecting local government. I'd like to hear what you got to say about it.
Ryan, what do you got?
Sure. Well, luckily, we can rely on the state to collect that sales and use tax, and certainly municipal governments would struggle to make those contacts and those collections. But through the home rule program, all municipal sales taxes are administered by the state and then remitted. So it is a great example of cooperation, which there's been some discussion about and some discussion about in the last panel. I think those other uses that you talked about remain a challenge. Airbnb, you can't look at the specific location on the site without renting the property, right? So those are resource intensive to track those down. I would say the real internet sales problem that cities are dealing with is the availability of those services and the detriment to local business. That's something where we need to find other avenues to promote the local access that Lauren has talked about.
Well, we've got 2 minutes left. Who's got a quick comment that they want to get in? Now, we want to get out on time, so you two,
I just wanted to ask if you're familiar with the $2 user fee that the city of Wheeling has enacted, and it's to help promote the public safety initiatives in the area. And so basically, I live in Ohio and I work in Wheeling, so I pay $2 a week as a tax or user fee. And if you're familiar with this, and it's to help promote public safety services to consumers, do you think it's a good idea? Do you have thoughts about it? And have you any other cities enacted something similar in West Virginia?
Great, lots of tax questions. Many of the larger cities in West Virginia have these municipal service fees that are designed to fund police and street services, and they're based on people who the cities know travel into the city, which are sometimes non-residents, but it's a service fee just like, at least has the same authority as fire service fees and utility service fees that are where the cities reasonably classify the users, and for roads, those are people who drive on them, and then assess the fee against those users. And so we have Wheeling City Attorney here as well, but Morgantown has a fee, Parkersburg has a fee, Huntington and Charleston, so they're very common funding methods here.
Good. All right. We've got 1 minute. 1 minute.
Thank you. Colorado has used this home rule to publish a sex offender register that was then considered by the Supreme Court to be stepping over the privacy of these sex offenders. I just wanted to ask you what's your take on that, and if it happens often that sometimes while protecting the privacy of customers, we overstep somebody else's privacy.
Wow. 1 minute for the answer. Who wants to address that one? Come on, Ryan.
Well,
you've done them all.
Under the bus.
That's why they pay you big bucks.
That's interesting. We do public records management, of course, at the city, and in general, records of crimes are public records. I'm not. I don't have much facility with legally protecting privacy rights, and that's why I wasn't really reluctant on that point. I thought somebody else on the panel might have a better answer for you. I'm not familiar with the challenge. It's not a home rule initiative here. We operate under the under our Open Records Act that would, I assume, would require cities to disclose that type of information.
12 o'clock. I appreciate everybody's time. Thank you to my panelists. Thank you to everybody here. Great questions. And I'll turn it over to Gabrielle.
Thank you. Thank you again to our panelists and to Jonathan for moderating. At this time, we will be moving to the event hall for lunch and our keynote address. It is right around the corner. Follow the crowd or find a student. We can point you in the right direction. Thank you.
Well done, sir. Thank you. Pleasure.